What's it with respect to item number 3, 4, and 5? I pray on behalf of respondents. What's it may not be taken up today. Because I have some personal difficulty.
3, 4, 5.
No, sir.
This is a long pending matter, my lord, as a suspension rather. So therefore, my lord, may I pray for my lord date, my lord, and sometimes among middle of May, my lord. Can be on 19th May, my lord.
19th, please.
No. 21st. So what is that date? Thursday.
19th is Tuesday.
Tuesday,
Oh.
19th is Tuesday.
And 21st, how many matters are there? Have you Thursday?
Not sir.
21st.
Can we on 26th then, my lord? Otherwise, it's not, otherwise it is not inconvenient.
Okay, okay.
Finish.
Not sir.
Oblige, lord.
26th?
Not
Finish.
Okay, Mr. S.C. Kerala, learned senior counsel, appearing for the Sam University, submits that he has some personal difficulties to conduct the case today in place for adjournment. So the side is not opposed to by the other side. So as agreed to by the parties, list this matter for hearing, for admission hearing on 26th of May.
much.
Item number 13, my lord. I have filed an affidavit in opposition today, my lord. It may be called for the record.
All right.
May I please, your lordship?
Yes.
With the consent of other side, I beg to mention item number 22. My lord, matter may be adjourned for the day and fixed after 4 weeks, my lord.
Why do you want to adjourn?
My lord, here we have got a list about of 354 numbers where the list of candidates got benefit. But after that list also, petitioners has got information that some other person has also got benefit. So my lord, as she's a widow and she could not collect the names of the other person, so some time may be needed, my lord.
What is the matter regarding?
My lord, it's a provincialization of service, my lord, matter.
No, why do you require to collect other names also?
Because my lord, some other from that
Names which you already have is not sufficient.
well,
You are Mr.
B. Sekia on behalf of S.G. Borua, my lord.
See, these matters of 2020 and it's a fixed matter also today.
Kindly.
Your good name?
B. Sekia.
Mr. B. Saikia, learned counsel, appearing on behalf of Mr. S.G. Barua, the conducting counsel for the petitioner, submits that since further materials are required to be collected from the petitioner, he prays that the matter be adjourned for 4 weeks. So it is seen that this matter pertains to the year 2020. And therefore, the petition counsel for the petitioner should not seek further adjournment on the next date. Next para, in view of above, this matter again after 4 weeks, any date on 11/6.
My lord, there is an interim order that may be continued, my lord.
Interim order passed earlier shall continue to the next date. All right.
May I please, Lordship, that to mention 2 items for listing for admissions. Pension related matter.
Go to the registry, please. Approach the registry for listing.
Please, your lordship, I beg to mention the listing of a writ petition for motion, lordship.
What is the urgency? When did you file it?
We filed it on 20th of April, lordship.
20th of April. It'll come in due course. Take it up with the registry. All right. Next.
May it please your lordship. I'd like to pray for listing of a writ petition for withdrawal
Okay.
and kindly fix a date within this week.
Tomorrow
Next.
for withdrawal.
Lordship, by next week if possible.
Withdrawal, isn't it?
Yeah.
We have it tomorrow. Why do you want it next week?
My, it's okay.
It's just for withdrawal, isn't it?
Yes. Thank you.
Yes.
Much obliged.
Daily list item 1 promotion.
May I please, your lordship? I am a drop teacher, my lord. My case was not considered on the ground of Udai's court, my lord.
Oh.
Not, my name is not reflected in the Udai's court. There is a judgment from this honorable court. This is a covered matter, my lord. Apart from that argument, my lord, I have another argument to make. So far, there is a vested right accrued in my favor. A division bench judgment of this honorable court. May I place the judgment before this honorable court, my lord?
What is your instruction?
My lord, as far as instruction is concerned, my lord, the earlier instruction is there, no fresh instruction is coming in, my lord. So, my lord, let the notice may come, my lord, in this matter, because notice is still not come, still not issued, my lord. So, notice may be issued here.
The reason why notice was not issued was that perhaps we could dispose of the matter at the motion stage.
Yes, yes.
That is why you were required to get instructions.
But up to date status, I have not.
And you don't have the instruction, you say that let notice go. What is this, Mr. U. Sharma?
I have received the instruction earlier on 25/3/2026, and thereafter I have not received any instruction, my lord.
My lord, as such, there is no adjudicable issues in this case, my lord. The issue raised in this writ petition has already been executed by this honorable court, my lord. Apart from that, the division bench judgment of this honorable court has said that I have a vested right in accordance with the 2011 Act, my lord.
Okay, you tell me the facts of the case.
My lord, the facts of the case, my lord, Lordship may kindly come.
You come to your synopsis.
I am a
Come to your
regular-
synopsis.
my lord. My lord. I am appointed in 1993, my lord.
Hmm.
As the assistant teacher, my lord. She joined in the service in 2002-194, my lord. Annexure 2. When the services of the teachers were provincialized, her name was not there, my lord. She was a third teacher. Though the post was sanctioned, her name was dropped at the time of provincialized. That post was kept vacant, my lord. Subsequently, the director of secondary education rejected her case by Annexure 4, my lord. However, she filed a writ petition before this honorable court, and the honorable court directed the director of secondary education to pass the appropriate order on or before 31/10/2016 in accordance with the provisions of the 2011 Act. Her name was recommended by the District Scrutiny Committee, Metro, my lord. Even after the recommendation of the District Scrutiny Committee, the Director of Secondary Education has not provincialized as instead, there is a rejection of her case was rejected by the DAC on the ground that her name was not reflected in the Dias Code, my lord. According to Act of 2017, there is no requirement for reflection of one's name in for higher school or higher secondary school. Not necessary, my lord. To that effect, this honorable High Court has passed several judgments, my lord. That has been on record, my lord. There is a contempt petition also filed, but contempt petition also not decided yet. It is kept pending, my lord. So this writ petition is come into existence for a direction from this honorable court to provincialize her case with effect from 1/1/2013. 1/1/2013, my lord, in accordance with the 2011 Act, my lord. So, Lordship may kindly see the judgment also. There is a judgment for direction from this honorable court. Is page 31, my lord. Lordship may can look at page 31 also.
There's one criteria as per the section 4, subsection 2 of the 2017 Act.
my lord.
It says that the tutors must have rendered at least 6 years continuous service.
But that is not applicable to her. She has a continuous service, no problem of that, my lord. My lord, may I permitted to place a order of this division bench of this honorable court, my lord?
No, how do we appreciate the fact that you have the continuous service?
There is a, Lordship may kindly see, my lord, the district committee recommendation of the district security committee, my lord. It has found that she has a continuous service and recommended for provincialize of a teacher. Lordship may kindly see that.
Where is that? Is
It is on page 33, my lord.
33?
33, my lord. It has checked everything, my lord. After checking everything, she was found eligible under the circumstances compliance of the order. May perhaps recommend or forward the name of Anita Boro to the higher authority for the necessary action and deem appropriate, my lord.
No, that is the conclusion. Before that, to arrive at that conclusion, what are the
My lord,
what are the findings?
Lordship may kindly see on query from the headmaster,
Hmm.
1, 2, 3. Of the school informed that as per letter of the Director of Secondary Education, number dated teacher including Mr. Anita Boro has been dropped in 1996 for being excess teachers. And it is for this decision her name is not included in the particulars at the time of the submission of particulars of the provincialization. There are the provision of three sanction posts of arts teacher in the school, while 2 posts are already filled up and 1 post is remaining vacant. The claim of the Anita Boro is that she is the next most senior arts teacher in the school, so her service should be provincialized. For provincial service of the teacher has to be established the continuous presence of teacher in the school. As per section 2H of the Venture Educational Institution, a teacher must be appointed on or before 1st January 2000 provincial service. The claim on Anita Boro is dropped in the school in 1996 illegally. But as it may, the school authority has submitted the attendance register of the Anita Boro on January 2010 onwards, my lord. It was perused by after perusal, the order has been passed, my lord. Recommendation has been passed that he has a continuous service. But moreover, she has a right under the 2011 Act, my lord.
What might be the date of page 33?
No date is available. Only there is a date in the forwarding that it is forwarded on 5/5/2017.
All right.
There is no date.
We'll issue notice at this stage. All right.
My lord, may I place the judgment of this honorable court?
You may place, but I'll issue notice at this stage.
My lord, if lordship found some adjudicable issue, in this case, lordship may issue notice, my lord. If there is a covered case, my lord, there is no need of issuing notice, my lord. It will further delay the matter, nothing else, my lord. If anything adjudicable, my lord.
Yes,
It-
where's the judgment? Where's the judgment? Which judgment?
My lord, in this
Two
matter,
judgments are there, my lord, in the record, my lord.
in the-
So
in
far
this-
the judice is concerned.
Please tell me the reference of the judgments. Reference of the judgment.
I am testimony Medak, my lord. One is testimony Medak, another is Mr. Kishore Kumar Nath, my lord.
Okay. Let us see testimony, Medak, first.
Testimony has been passed para 9, my lord. Para 9.
Kishore Kumar Nath.
Kishore Kumar Nath is the first case, my lord.
So let us go to the first case then.
Yes, my lord. Para 16, my lord. Para 16, my. Therefore, a conjoined reading of the provision referred to herein effect in respect of Rule 17, that there is no requirement for the name of the teachers working in the Fensar High School as well as Fensar Higher Secondary Schools, as defined under 2X and 2Y of the 17 Act, to have their names captured by the dice, as is otherwise required in case of teachers, tutors whose services as provincialized Fensar ME School or Fensar Lower Primary School, as well as Fensar Upper Primary School, as defined under 2C, 2Z of the Act, wherein the names of such teachers or tutors are required to be captured by the dice court. In the backdrop of this court, take into consideration the case of the petitioner before this court in the present batch of writ petition. The learned counsel of the petitioner has submitted that concerned respondent authorities have not proceeded the proposal for provincialize of the services of the petitioner who are working in the Fensar High School and the Fensar Higher Secondary School on the ground that petitioners' names are not captured in the dice code. It is also the case of the petitioner that concerned authorities have issued communication not to process for such proposal of provincialize of service of teachers, tutors whose names has not been captured in the dice code. This court, on the basis of the above analysis of the provision of 2017 Act, is of the opinion that insistence of the respondent authority of the names of the petitioner who have been rendering service in the Fensar High School and Fensar Higher Secondary School to be captured in the dice code of 910 is contrary to the Act of 17, and it is the mandate of the 17. It is not the mandate of the 17 to fulfill the such requirement in respect of the such teachers and tutors working in the Fensar High Schools and Fensar Higher Secondary to have the name captured in the dice code for 910. Such insistence is arbitrary and contrary to the provision of 2017 Act like interfered with. This is the first case, my lord. In the second case, my lord, this case has been followed, my lord. In the second case, my lord, ceremony testimony Medak versus State of Assam, my lord.
What is the relevant provision under the 2017 Act for provincialization?
17 Act, the 11 provision is mentioned in the, this is 2X and 2Y of the 17 Act.
You have a copy of the book?
Yes, my lord.
What would be the page number?
This is the book, my lord. This is the book I am.
Correct. What would be the page number?
It is 103, my lord.
You are saying 2X.
2X, my lord.
2X. Where is the 2X?
That it is 103 2X tutor. Fensar is the primary school 107, my lord. Primary pass by Fensar 2X. 2X is 106, my lord.
The name of the act is Assam Education,
Assam
Provincialization
Education,
of
Provincialization of Services of Teachers and Reorganization of Education Institute Act 2017.
2017.
Yes, my
The
lord.
relevant provision,
Relevant provision is 2X, my lord, Spencer High School.
section,
My lord,
section.
section 2X, my lord. 2X, my. Spencer High School means high school
Yes.
imparting education for class 10
Hmm.
and established by the people of the locality prior to 116, which was received permission from the state government and recognition of the Board of Secondary Education Assam on or before 116. And whereof the services of teacher have been provincialized under any act enacted by the state legislature so far.
Hmm.
This is the provision. Madam. According to this provision, there is no requirement for the
No, this is merely a definition of venture high school. That's
my lord, that has been followed, whether the requirement is required or not by this honorable court, my lord. There is so many judgments, my lord. I have just placed 2 judgments, my lord.
This cannot be the provision. This is only a definition of venture high school. That's all.
That is therefore the conjoint reading of the provision referred to the Act of 2017. The requirement of the names of the teacher of venture high school as well as the venture high school is a definition 2X and 2Y of the Act to have their names captured in the dias code, as is otherwise required in case of the teachers and services of the provincial or venture lower primary school, venture high school, as defined in the 2ZA and 2ZB, 2ZC of the Act of 2016, wherein the names as tutors are required to be captured by the dias code. There is other provisions also there, where there is the dias code is required, my lord. In these 2 cases, higher secondary and high school, dias code is not required, my lord.
My lord, section 3, subsection 13, my lord. In my book, it is 112. Serial number 3. The concerned venture educational institution must have the required infrastructure as specified by the concerned university to which the college is affiliated in case of venture degree college, and as specified in the schedule of the right of children to free and compulsory education Act 2009, as far as the practicable, and having dias code for the year 2009-10 or prior to death in case of venture primary or upper primary school, and in case of all other educational institutions, the concerned institution must have the required infrastructure as specified in section 10 of Assam Non-Government Educational Institution Regulation and Management Act 2006 as far as practicable.
Lordship, this is school already provincialized by law. This school has already been provincialized. The teacher services of the teacher also provincialized. She is a drop teacher, my lord. So that provision is not applicable.
No, that's for the.
না ডায়াস কোডৰ কথাটোৱে মানে এইখন স্কুলটো হৈ গৈছে না, এজন মানুহে হোৱা নাই।
Anyway, we'll consider this at a later stage. We'll issue notice at this stage. I heard Mr.
My lord, the lady is waiting from 2013, my lord.
D.N. Bhattacharya,
It is 2026, my lord.
learned counsel for the petitioner, who submits that this is the second time the petition is before this court. Stop the earlier writ petition being WPC number 2415 of 2016 was disposed of by order dated 24/2016. By directing the petitioner to submit a representation seeking provincialization of her service. Before the district scrutiny committee, bracket secondary, Kamrup Metro, Gauhati. Stop in the event of filing such representation. the committee shall scrutinize the services of the petitioner. And if it is found that she is eligible for provincialization under the 2011 Act in the vacant post of third assistant teacher of the school, her name shall be recommended before the Director of Secondary Education for necessary action within a time frame. Now, pursuant to the said direction, the district scrutiny committee headed by the Deputy Commissioner, Kamrup Metro, found the petitioner to be eligible to be considered for provincialization. As he was found to have been a drop teacher from the school in 1996 illegally. No, drop in the year 1996. No, illegally you cancel, okay? And that the school authority had submitted attendance register of the petitioner from January 2010 onwards. Stop. The finding of the committee was forwarded to the Director of Secondary Education on 5/5/2017. However, the director, white letter dated,
Here also no date, my.
there is no date.
Another order is there, my lord. Where is dated, my lord?
White letter dated nil, wrote to the Secretary to the Government of Assam, Secondary Education. Stating that without finding the name of the petitioner in the UDICE data in the year 2014, 2015, and 2016, it could not be ascertained that the petitioner had rendered at least 6 years of continuous service as on 1/1/2017 from the date of joining, as required under section 4 bracket 2 bracket Roman 3 of the Assam Education open bracket Provincialization of Services of Teachers and Reorganization of Educational Institutions close bracket Act, 2017 as amended in 2018. So therefore, the director recommended that the case of the petitioner cannot be considered for provincialization. So I agree, the petitioner is again before this court. So, see, one thing is there, director has written to the secretary.
Now, there
But-
is another order, my lord.
but where-
Logically, page 37, my.
Huh?
It is a direct, my lord. 16/10/2025. Here it
Okay.
is by the government to the.
Okay. Then what is the last line? What is the last line?
stating that result and in the petition of intervening direct salary with their demarcation and 60 to have the asserted and the petition of then this is the criminal service based on 1 submitted and the date of withdrawal as described in section 4 to debit to record is eliminate some education is the provincialization of service which will be organization of education exclusion that was at 2017 as amended in 2018. Therefore, the directive will consider this petition not be considered as provincialization.
Agree. From there you cancel, agree if not. From agree onwards you cancel. Consequently, the Deputy Secretary to the Government of Assam, Department of School Education, White communication dated 16/10/2025, bracket Annexure 9. Inform the petitioner that her service cannot be provincialized due to non-fulfillment of the criteria laid down in section 4, bracket 2, bracket Roman 3 of the Act of 2017 as amended in 2018. So I agree the petition is before this court. Next para, the learned counsel for the petitioner submits that the impugned communication cannot be sustained in view of the fact that the requirement of capturing one's name in the UDICE data is held to be not mandatory by a coordinate bench of this court in Kishore Kumar Nath versus State of Assam and others. 2023-0 SC, I'm sorry, 2023-0, then Supreme, bracket GAU Gauhati, 120, which was also subsequently relied upon in WPC number 2054 of 2025. Bracket Srimati Ditomoni Medak versus State of Assam and 3 others.
ये वस्तु testimony.
A copy of the judgments in the 2 cases has also been produced by the learned counsel for the petition. So under this circumstance, the respondents will have to show as to why reflection of the name in the UDICE data has been insisted upon despite the decision rendered by this court as referred to herein above. Stop, although the matter could have been taken up for disposal as a covered matter, but since instructions have been sought, instructions was required to be obtained by the learned standing counsel for the secondary education department. This court deems fit and proper to give one opportunity to the department to project their case by adequately instructing their standing counsel or filing an affidavit opposition on or before the next date. Next para. To give such opportunity, let notice of motion be issued, returnable by give a date. 9/6/2026. Mr. U. Sharma, learned standing counsel, secondary education department, accepts notice on behalf of the respondents
Respondent number one,
One,
two,
one, two,
respondent number one, two, and four,
1, 2, and 4.
and district commissioner.
Who?
That-
Who are you pointing?
two.
Demand 1, 3, and 4.
Miss
and
S.
order
Kuar.
1, 2, and 4, and
S.
district
Kuar,
commissioner.
learned government advocate, accept notice on behalf of respondent number 3. Notice is there for complete, extra copies within 2 days. List the matter again, also and so on. 9/6. On which date an attempt shall be made to dispose of the case finally?
Oh.
My lord. There is another judgment of this. I have no, Lordship has given no opportunity
You-
to place the matter.
You produce on that day, we'll hear you. Today I'll give one chance to Mr.
Yes.
Let him satisfy us.
Obliged.
Right.
Item 30 of the supplementary list.
May it please the lordship.
Yes, sir.
My lord, I am on caveat, my lord. My lord can hear.
Caveat. Yes, Mr. Bora.
Yes, madam. My lord, petitioner before lordship is a senior most teacher, my lord. As a senior most assistant teacher of my lord RA Memorial Higher Secondary School, my lord. And my lord, he has also highly qualified, my lord. And my lord, without considering him, my lord, as well as second senior most teacher, my learned friend client, respondent number, my lord, 4, my lord, was appointed as a in-charge principal, which is challenged before your lordship. Please may kindly see page annexer 12, page 33, my lord.
When was the order passed?
And this order has been passed on 12/2/2026, but we are not getting this, and thereafter, my lord, we have a late, my lord. Because of that, they did not give us, my lord.
So will issue notice?
Issue notice because of that, my lord, at least this input order may be stayed because of that. Two senior most teacher in suffering, my lord, he is given.
That will be considered in the returnable date. Interim order, interim prayer.
My
Because
lord, at this state, my lord, the inspector of schools may be allowed to run the school. My lord, otherwise, my lord, junior most teacher, if your lordship, go to page 10, my lord, page 10, your lordship. Page 10, petitioner, my lord, serial number 1 is MAB my lord. He was joining on 30/11/93. And my lord,
no, that's
Rafiqul
okay.
Islam.
That's
He is
okay.
also senior, they did not consider it, my lord.
You will take your word at this stage. You are senior. Respondent number 4 is the third senior most.
My lord.
But order has been effected in February. So we'll
February,
give one
but they did not
opportunity.
provide us, thereby this problem is coming.
That's why. So we'll give them one opportunity. I'm not rejecting your interim prayer. We'll issue notice on that and we'll consider a returnable date. Heard Mr. N. Okay. Heard Mr. N. Bora, learned counsel for the petitioner, who submits that the petitioner, despite being the senior most teacher, senior most assistant teacher in RA Memorial Higher Secondary School, Rajnagar, the respondent authorities write the order dated 12/2/2026, bracket annexer 12, has given the respondent number 4, has allowed the respondent number 4 to act as the headmaster in charge of the school, along with financial powers. To stop, the learned counsel submits that the impugned order could not have been passed in such a manner by ignoring the seniority and the fact that the seniority of the petitioner and the fact that the petitioner is capable and qualified in all aspects. The learned counsel therefore submits that the interim order dated 12/2/2026 should be interfered with, and the petitioner should be allowed to hold the post of headmaster in charge of the said school. In view of above, issue notice of motion returnable by 3 weeks. Mr. Government, anyone, department? Secondary.
Secondary, my lord. Madam, second.
Mr. U. Sharma, Learned Standing Council, Secondary Education Department, accept notice on behalf of respondent numbers
Second.
1,
33.
2, 3. 1, 2, and 3.
My lord.
Stop at this stage. Mr. A.R. Bhuyan, Learned Senior Counsel, appears and submits that he has instructions to appear on behalf of respondent number 4. He further submits that the respondent number 4 has also filed a caveat. Stop. As such, notice is accepted by Mr. N.M. Majar Bhuya, Learned Counsel, on behalf of respondent number 4. Petitioner to serve requisite copies of the petition to the Learned Counsel appearing for the respondents to. Also issue notice on the interim prayer, returnable by 3 weeks. Learned Department Counsel shall obtain instructions by the next date. List again on 5/6/2026.
Matthew. Obliged, deeply.
Then caveat discharged, okay? Yes.
May I please, Lord? Lord, the petitioner, my lord, he was initially appointed as assistant teacher, my lord, and subsequently promoted to the post of assistant headmaster by order 5/8/2017, page 15.
Assistant teacher, then assistant headmaster.
Assistant headmaster. Now, my lord, the regular headmaster will retire, my lord, on 30th of this month, my lord. And inspector of school, my lord, forwarded a senior list, my lord, page 16.
Now, where is your name at page 15? Abdul.
Lordship, number 1, my lord.
This is in terms of seniority.
Lordship. And there is a court case also, and after the judgment of this honorable court, promotion was made to the post of assistant headmaster.
2017.
Lordship. And since 2017, he joined, my lord, on 8, my lord, and he has been working as assistant headmaster.
What is page 16?
Page 16, my lord, is the seniority list, my lord, of the school. It was forwarded, my lord, on 21st of this month, my lord, prepared on 24.
Yes, you are number 3.
Number 3, my lord. No, I am at number 4.
What happened to number 1?
Number 1 is not qualified for headmaster, my lord. He did not have B.Ed or.
There is no name against number 1.
No.
There is no name. It starts straight away from number 2.
Or number 1 is not a lordship. Number 1 because he is the headmaster. He prepared this list.
Then what about number 3?
Number 3, my lord, he is the assistant teacher. His date of joining, my lord, 23/2020.
There are 2 persons above you.
Yes, my lord.
Okay.
One is, my lord, he did not have, my lord, B.Ed degree, my lord. So he cannot claim the post of in-charge headmaster.
Who does not have B.Ed degree?
Number 2,
Raja.
Lordship.
And number 2?
Number two, he completed B.Ed, my lord, in 2021.
So,
Now, my lord, in the cadre, my lord, lordship, kindly see the cadre, my lord. Now, assistant headmaster, my lord. After the retirement of the headmaster, my lord, inserts should have been given to the assistant headmaster. But in this case, my lord, seniority list was prepared and recommended the name of the assistant teacher. And therefore, my lord, I file a representation before the authority. It is pending, my lord.
you
And-
have, you are working as assistant
Assistant headmaster.
headmaster.
The post of headmaster will be fallen vacant, my lord, on 30th of this month.
And what about these other two teachers? What are they?
They are assistant teacher, my lord.
Assistant teacher.
Lordship.
There's a separate cadre for assistant headmaster.
Assistant headmaster falls in cadre 3. Here, my lord, graduate teacher also included. Graduate teacher, demonstrator, Hindi teacher. But in the chronologically, my lord, first, my lord, number 1 is assistant teacher and assistant superintendent. Then, my lord, graduate teacher, 2A,
From where are you saying that?
lordship,
Page number?
page 23.
Page 23, rule,
Class and
rule 3.
Rule 3, class and cadre. A, my lord, class 1, principal post, my lord. Then
Hmm.
class 2 includes my lord, vice principal and postgraduate teacher, headmaster, superintendent. Now class 3. It includes the cadre of assistant headmaster, assistant superintendent, then 2A, graduate teacher, B, Hindi teacher.
Then,
Now, lordship, kindly turn to page 48, schedule 1, my lord.
where is the assistant teacher?
Assistant teacher is a graduate teacher, my lord.
Okay,
They-
it's
they are
the same
taking-
thing.
Lordship,
Graduate teacher and assistant teacher, same thing.
same, my lord.
So you are in the first preference.
Lordship.
And where is the recommendation? Implement recommendation?
Page 16, my lord. This is the
16?
list.
This is
Lordship.
a pro forma only.
It was forwarded, my lord. Recommending the name of the.
So tell me one thing, serial number 2, Raja
Lordship.
Akbar. He is not a he's not a B.Ed.
No.
Then what is this?
My lord, column number 16, my lord, regarding.
See, you should get this enclose a type copy. We have to strain our eyes to read what you have annexed here. Every time we find these things. You should have a typed copy of page 16.
Lordship.
Difficult to read.
Lordship will take care, my lord.
Who is this serial number 3? What is his name?
Zulhas Ali Ahmed, my lord.
Juhash.
Lordship, we have made him party, my lord, respondent number 4.
So what about him? He's senior to you,
He's senior to me, but his cadre is junior assistant teacher.
assistant teacher.
Lordship.
Okay.
His designation assistant teacher.
Then your representation is dated April
Lordship. Page
22nd.
17.
When was the pro forma prepared? 20th
Lordship.
of April. Yes, who is appearing for the respondent?
I am here.
Yes, tell us.
But since it is, my lord, now in charge is the inspector of school, my lord, and moreover, my lord, one private party also there, my lord. So, my lord, in this stage, my lord, notice may be issued. Respondent number 4 is the private party, my lord.
Inspector of School is in charge.
Yes, my lord.
Is it so?
Discharge has not been given till date, my lord.
But
Mr. U. Sharma,
It is pending
no,
before
but
the,
the
pending
charge
before the
charge of the school is under inspector of school.
where? From where do you say that? Show me.
it is
No.
pending before the director. Director was pending us. Order.
You are confused with other case. You are mixing up with other case or what? Headmaster is yet to retire.
Oh,
He
yes,
will retire on 30th of April.
yes, this is the seniority. Yes.
Even before he retires, charge is given to the
No,
inspector
no.
of school.
No.
Then. See, the question here is petitioner claims to be the assistant headmaster.
Yes,
Now, when headmaster is retiring in the end of this month,
yes,
the headmaster has given the two names ahead of him.
yes,
They are only assistant teachers,
yes,
while he is the assistant headmaster. One of them is not even BEd.
yes.
So, having regard to this Rule 3 of the 2018 rules, the order of preference is given there.
So, my lord,
A petitioner apprehends that he will not be given the thing.
yes, my lord.
And the,
So
My
what
lord,
is to
it
be
is
done?
the apprehension, it is the apprehension of the petitioner, my lord.
And apprehensions also, there is some
Regarding the in-charge headmaster. my
there
lord.
is some backing also. Page 16 is there.
Yes, page 16 is the seniority list, my lord. So, my lord, still, my lord, headmaster is working here, my lord, in that school. So, my lord, let the notice be issued here. And here also, my lord, in the prayer also, it is stated directing the inspector of school BDC Borpeta not to allow the respondent number 1 for in-charge headmaster of the school. And moreover, here, my lord, in the interim further, it is prayed that pending disposal of the petition, your lordship would be pleased to interim order directing the director of secondary education Assam to allow the petitioner to hold the post of in-charge headmaster of Kadong High School till the post is filled up by regular process and pass any other appropriate interim order. So, my lord, in this stage, my lord, notice may be issued because headmaster is still working here, my lord.
Heard Mr.
R. Ali.
R.
Ali.
Ali, learned counsel for the petitioner, who submits that the petitioner is working as the assistant headmaster. What is the name of the school?
Kadong High School. At Borbet.
In Kadong High School. In Borpeta. And that the headmaster of the school is due to retire on 30th of April 2026. So the learned counsel submits that the headmaster has prepared a pro forma of the seniority position of the teaching staff of the school on 24/2026, wherein he has placed the respondent number 4 above the petitioner. Stop. The learned counsel submits that the petitioner apprehends that the respondent number 4 would be allowed to hold the charge of in-charge headmaster of the school. Despite the fact that he is only an assistant teacher, while the petitioner is the assistant headmaster. Stop. The learned counsel has drawn the attention of this court to Rule 3 of the Assam Secondary Education, open bracket, Provincialized Schools, close bracket, Rules 2018, wherein the Class 3 teaching cadre includes assistant headmaster, assistant superintendent, as well as graduate teacher, amongst others. Stop. In the order of preference, the cadre of assistant headmaster precedes graduate teacher. And stop. Therefore, the petitioner has the right to be considered for holding the charge of in-charge headmaster of the school. Stop. Aggrieved with the pro forma, the petitioner has submitted a representation before the Director of Secondary Education on 22/4/2026, which was received by the state authority on 23/4/2026. The petitioner submits that since the representation is yet to be considered, the headmaster of the school due to retire shortly, he apprehends that he will not be allowed to hold the charge of the headmaster of the school, and therefore he is before this court. Next para, in view of above, issue notice of motion returnable by 3 weeks. Mr. U. Sharma, Learned Standing Counsel, Secondary Education, accept notice on behalf of respondent numbers. One, two, and three. Petitioner to take steps for service of notice upon respondent number 4 by speed post within 3 days. Insofar as the interim prayer of the petition is concerned, this court finds that the same to be premature. And therefore, a specific direction as prayed for cannot be passed at this stage. Full stop. It is, however, provided that in the event the incumbent headmaster retires from service, the post vacated should be filled up in accordance with law, and also after considering the representation submitted by the petitioner on 22/4/2026 before the Director of Secondary Education, which was received by the said authority on 23/4/2026. List again on so and so.
All right.
For orders, item 18.
Okay. None appears for the petitioner when the matter is called. The matter has been pending for two reasons. Stop. Firstly, the petitioner has not taken steps for service of notice upon the respondent number 7. So when the matter was listed on the last two occasions, the learned counsel for the petitioner, Miss A. Bujar Barua, learned counsel, submitted that she needs to obtain instructions from our client as to whether he intends to pursue the matter further or not. So, however, as Miss A. Bujar Barua is not present today, it cannot be said. It's not present today. There is no one to inform the court that the petitioner would like or would not like to pursue the matter further. What do you suggest, Ms. Das?
One last chance may be given, your lordship. A short date may be given, your lordship. 2016 matter, your lordships, a long time pending matter.
But what have you done? Have you filed affidavit?
No, your lordship.
You have not filed.
16 matter, we have replaced the, we are not able to trace the file, your lordship. We have asked it.
That cannot be the ground. You cannot trace the matter. What do you mean? Okay. In the interest of justice, one final chance is granted to the petitioner to take appropriate steps in the matter, failing which court may consider passing appropriate order. List again after 3 weeks.
I'm deeply obliged.
Wait, please, your lordship. No affidavit filed in this case.
Who is respondent numbers 3 and 4?
Lordship Director. Secretary and Director of Secondary Education, Lordship. 3 is Secretary and 4 is Director of Secondary.
Notice is served or not? Notice is served or not?
I am for 1 month.
One or two.
Take first steps.
Lordship.
It, from the office note dated 23/4/2026, it appears that notice is not yet served upon respondent numbers 3 and 4. Since neither ID card nor unserved notice has returned back. Upon the circumstance, petitioner to take fresh steps for service of notice upon them by speed post within 3 days. Mister, you are filing anything?
I am for 1 month. Respondent who is already retired. Respondent number 1 month. Who is already retired from office, sir.
Already retired.
Retired.
So no more submission from one.
One thing is that they have filed an IA, my lord. They have filed an IA, my lord.
Mr. P.K. Bora, learned counsel appearing for respondent number 1, submits that respondent number 1 has since retired from service. List again. After 3 weeks.
Lordship. Oblige, your lordship. Taking order.
We have complied, my lord.
And it's
Rejected.
Lordship, may I go through it through the order and then Lordship may fix another date because
No, we're closing it now. If you want to challenge, it's up to you.
no, Lordship, whether they have done it in, because earlier also they have considered our appeal and disposed of the matter. By holding that since District Scrutiny Committee did not recommend my name, therefore I am not considered. The Honorable Court set aside that appeal order and gave a specific direction as to how this present. appeal
Okay,
has
show
to-
me the specific order by this
Lordship.
court,
Yes, Your-
page
page 14, Your Lordship.
operative 15.
Operative, just before above the last paragraph, Your Lordship.
You read from page 14, in view of above.
Now, before that, Your Lordship, a direction, an appellate authority is required to examine the grievance raised before it on merits, and examining the contemporaneous record is required to arrive at a conclusion as to whether the grievance raised before him in the appeal merits acceptance or not. However, the said exercise is found not to have been taken recourse to by the appellate authority while disposing of the appeal preferred by the petitioner herein. In the event the name of the petitioner was not so recommended by the District Scrutiny Committee, it was the bounden duty of the Secretary to the Government of Assam Department of School Education to refer the matter to the State Level Scrutiny Committee for its consideration in terms of the provisions of section 14 of the so and so Act. In view of the above position, the order dated 15/9/2023 passed by the Secretary to the Government of Assam Department of School stands aside. The Secretary to the Government of Assam Department of School Education shall reconsider the appeal dated so and so preferred by the petitioner before him in terms of the directions passed by this court by order dated 26/7/2023 in so and so, and thereafter pass a speaking order in the matter. In the event it is found that the name of the petitioner has not been recommended by the District Scrutiny Committee, the said appeal shall be placed before the State Level Scrutiny Committee for its consideration. The State Level Scrutiny Committee, in the event of such appeal being placed before it, shall consider the matter by examining the contemporaneous records and also providing an opportunity of hearing to the petitioner as well as the respondent number 6 hearing. The Secretary to the Government of Assam Department of School Education or the State Level Scrutiny Committee shall consider the said appeal so and so. So earlier they have said that since District Scrutiny Committee did not forward my name, therefore I am not considered. This Honorable Court says that, Your Lordship, only because my grievance is that the District Scrutiny Committee did not recommend my name. Whether that non-recommendation was in accordance with law, that was to be considered by the appellate authority, which was not done while the earlier appeal was disposed of. So that that impugned order was set aside and the direction was made that you go through the contemporaneous record and find out whether the non-recommendation by the District Scrutiny Committee is in accordance with law or not. Whether that has been done or not, Your Lordship, let me go through once, and then if it is next week, Lordship may fix up the date. Here I am finding that in impugned order, they are saying that District Scrutiny Committee did not send your name.
SLC of chairperson of the SLC passed this order after going through all this record and after hearing the petition in person.
Whether this non-recommendation by the District Scrutiny Committee was justified or not, that has to be considered by the State Level Scrutiny Committee.
Mr. P.K. Bora, learned counsel appearing for respondent number, appearing for the sole respondent, has produced an order dated 27/4/2026, passed by the Director of Elementary Education, and submits that the order of this court has been complied with.
Sorry, madam, respondent number 2, madam.
Mr. M.H. Laskar,
Lordship.
correct? Learned counsel, for the petition, on the other hand, submits that this court had passed a specific order on 10/1/2025 in WPC number 413 of 2024. And therefore,
Yeah,
he
basically,
prays that he may be given some time
yes,
to go through the
Lordship.
order passed by the Director of Elementary Education and get back to the court to make his submission. Considering the same, this is the matter again. In 11/5.
Obliged, Lordship.
Copy of the order dated 27/4/26 produced by Mr. P.K. Bora is kept on the record. Is retained on record and marked as X for identification.
I'm deeply opposed.
Petition item 2.
It substantially hurt the matter.
I had concluded my part. Matter
We have forgotten what you have submitted.
my lord, that is the appointment to the post of assistant professor, my lord, that aquaculture and fish
Yes,
nutrition.
kindly
Yes, my lord,
briefly
I have
recapitulate.
prepared a short synopsis of my arguments, my lord. But the respondents are not here.
Who's the respondent?
Mr. I. Thakur had appeared, my lord, for the university.
He's not here today?
He's not here.
What happened? Anyone appearing for him? Respondent, who is the respondent?
The private respondent has not appeared in spite of notice, my lord.
No, the official respondent,
The Assam Agriculture University.
Agriculture University. Private, you are challenging the appointment of the
Yes.
private respondent. Aquaculture and all that.
Aquaculture, on the ground that by a subsequent corrigendum, my lord, a separate discipline has been merged. Initially, it was advertised for the post of assistant professor in the discipline of aquaculture. Subsequently, by corrigendum, the fish nutrition has been added, ma'am. And they have relied upon the minutes of the academic council by which they say that there is some relevance. I had demonstrated before your lordship that the courses are absolutely separate, distinct and separate.
What do we do now? Mr. I. Thakur is not there.
Can it be taken up day after tomorrow, madam? Since it's a part-heard matter.
What is what?
Either
Are we-
Thursday or
15,
next Tuesday. no.
next week? Fifth
Next
means
Tuesday, no.
5th of May. 5th of May.
7th of May, madam. 5th of May, I've got another matter.
7th of May.
7th of May.
Okay. He's right. Although Mr. N. Deka, learned counsel for the petitioner, is present. But see the time? Last order was 7th.
But it has
7th
been listed today, madam. So
7th of April, isn't it? Now what will happen? 7th is the 7th to 7th, 1 month. It's possible, isn't it? Okay. Although Mr. N. Deka, learned counsel for the petitioner, is present, but Mr. I. Thakur, who represents the respondent, Assam Agriculture University, is absent. And no reason has been assigned for his absence. So, since the matter is a part-heard matter, let the matter be listed again on 7th of May 2026 for consideration as part-heard. You can have a word with him also.
I will.
All right. So that we have got. Okay. All right.
Item numbers 7 and 8.
Milord, in this case, Milord, the maintainability has been questions by the respondents, Milord. I would like to address on this issue first, Milord. Since
Three
the
matters, they are all analogous.
analogous,
Yes.
3 cause of actions, 3 writ petitions, parties are same.
Okay, you are for the, all the 3
He is
Yes.
for the writ petitioner, my lord.
Hmm.
I am for the faithful law college.
law college.
We have raised that maintainability point
Okay.
because it's a private college, my lord. Doesn't perform any public duty. Therefore, we are saying, my lord, is moreover, my lord, this is a contractual appointment. That too by a private body. So therefore, it is not maintainable. Well, since I have raised the issue, I may address your lordships first, then my learned friend will reply.
No problem.
Okay.
If the lordships would kindly take the affidavit, my lord. Oh, no.
Tinta cases, no? Full case.
Lordship may kindly take this 4903.
Yes, affidavit is filed.
Precedent
Aye.
of the governing body.
Respondent number 4.
Fourth, yes.
Hmm.
If a lordship would kindly come to page 303, Miller. Paragraph 3, capital A.
Can you tell me the inner page number?
Inner page number 2, Miller.
2. That running page is not there, that's why.
Okay, two, my lord.
2 paragraph number,
Paragraph 3, capital A, towards the bottom of the
Yes.
page. Yes. That Tezpur Law College is not a statutory body as it has not been created by any statute and its existence is not dependent upon any statutory provision. The college is affiliated to the Gauhati University for the sake of convenience, namely for the purpose of recognition and syllabus or the course. Therefore, in the humble submission of the answering respondent, it does not confer any enforceable right on the petitioner against the answering respondent. It is pertinent to state herein that re-jurisdiction of this honorable court can be invoked for enforcing a public law element and not to enforce a contract of personal service. A contract of personal service includes all matters relating to service of an employee, that is confirmation, suspension, transfer, termination, etc. The answering respondent begs to state that there is no iota of doubt that the aim and objective of the college are to impart legal education, which is a public function. However, the issue herein is with regard to termination of service of the petitioner, which is basically a private law remedy. In the present case, there is no question of public law element involved, inasmuch as the grievance of the petitioner is of a personal nature, and therefore no writ would lie against the termination of the service of the petitioner by the governing body. So, my lord, basically this is our case, my lord. And if your lordship would kindly come to paragraph C, my lord. Page 4. That undoubtedly the college imparts legal education and imparting education involves public duty. And in that sense, a public law element can be said to be involved. But relationship between the petitioner herein and the answering respondent is that of an employee and a private employer arising out of a private contract. If there is a breach of the agreement of private contract, the same does not touch upon any public law element. Therefore, the answering respondent cannot be said to be discharging any public duty in connection with dismissal of the petitioner to attract Article 226 of the Constitution of India, which is a public law element. Well, basically, this is the premise on which we would like to say, my lord, that the writ petition is not maintainable. End of the day, my lord, there is a contract between the college and the petitioner. And assuming, my lord, by terminating her service, the contract has been violated. So remedy is to maintain a suit. Remedy is not to enforce a, my lord, re-jurisdiction under 226. Because end of the day, it is a contract of personal service. Now,
how are they
law is
appointed?
well,
How are they appointed? By way of a contract agreement?
yes, yes.
There's a contract agreement.
Yes, yes. Well, I'll place judgment. I think this should suffice. If your lordship should kindly have a 2008 8 SCC 92 photo दिया है सर ने? Well, these are all well settled propositions, Miller.
Paragraph?
Paragraph 17 at page 105. Enforcement, kindly see the question which was, my lord, the frame. Enforcement of a contract of personal service. Where relationship of master and service is purely contractual, it is well settled that a contract of personal service is not specifically enforceable, having regard to the bar contained in section 14 of the Specific Relief Act. Even if termination of contract of employment by dismissal or otherwise is found to be illegal or in breach, the remedy of employee is only to seek damage and not specific performance. So this is another aspect, my lord, flowing from section 14 of the Specific Relief Act. Courts will neither declare such termination to be nullity, nor declare that the contract of employment subsists, nor grant the consequential relief of reinstatement. The three well-recognized exceptions to this rule are, whereas civil servant is removed from service in contravention of Article 311 of the Constitution, where a workman having protection of Industrial Disputes Act is wrongly terminated from service, where an employee of a statutory body is terminated from service in breach or violation of any mandatory provision of a statute or statute rule. Only in these three situations, my lord, that one can enforce the contract of personal service. And admittedly, my lord, the present case does not fall in either of the three exceptions. There is thus a clear distinction between public employment governed by statutory rules and private employment governed purely by contract. The test for deciding the nature of relief, damages, or reinstatement with consequent relief is whether the employment is governed purely by contract or by a statute or statutory rule. Even where the employer is a statutory body, where the relationship is purely governed by contract with no element of statutory governance, the contract of personal service will not be specifically enforced. Conversely, where the employer is a non-statutory body, but the employment is governed by statute or statutory rule, a declaration that termination is null and void and that employee should be reinstated can be granted by courts. So, my lord, these are the case laws which have been relied upon. So, my lord, the law is well settled that you cannot enforce a contract of personal service. You can't even apply for reinstatement. All that you can do, you have to file a suit where you have to establish that the dismissal was wrong, in which case you will be entitled to damages. So there is a specific bar, not only by the Constitution, my lord, but also by Section 14 of the Specific Relief Act.
Let us have that specific relief
Yes,
act.
yes.
What does it say? Section 14.
14. Section 14 says, my lord, which all are the contract which can be enforced.
Now, do we have a copy of the contract agreement
Yes,
by which
yes,
they were
yes,
appointed?
Yes, yes. Please come to the writ petition, my lord.
Page?
Yes. Page 28 is the appointment order.
Section 14, just 28. 28,
2(8) of the writ
an
petition.
extra 3.
Yes.
Hmm.
As per panel made by the selection committee for whole-time principal cum secretary governing body of the college, held on 2/2/20, and on unanimous approval of the panel by the governing body, held thereafter, you are appointed as a whole-time principal cum secretary of the governing body of the college with effect from 3/2/20. You would be offered a lump sum salary of 60,000 per month from the date of joining, besides 5,000 per month as house rent. So this is the appointment order, my lord. And there is no dispute that it's a, my lord, private college. And a private college, my lord, the appointments are made in those terms.
It says you are appointed as a whole-time principal.
Yes,
From secretary.
yes,
Probation 1 year.
yes.
But where's the word contract?
No, my lord, it's a contractual service only, my lord. It's a private body.
Hmm.
Otherwise, if it is a regular, then you would have been entitled to, my lord, scale of pay and all this benefit. But something like consolidated pay. End of the day, my lord, their only point is, in some of the colleges, government gives some grants. Nominal amount, I think for 1 or 2 years it was given. Lordship knows, my lord, that the law on this point developed sometimes in that Ajay Hasia's case, my lord, 1980s. Then, my lord, Lordship would recollect ICAR, which is an adjunct of the Department of Agriculture, Government of India. Supreme Court says it is not an authority under Article 12. So, my lord, end of the day, whether there is deep and pervasive control of the state. Only when there is a deep and pervasive control of the state, then an authority can be assumed as an authority discharging public function. Lord, I'll give an example. Andi Mukta's case, the Honorable Supreme Court says that, for example, my lord, supposing I am working in a private employer, under a private employer. Supposing I am denied my Provident Fund dues. Because Provident Fund Act cast a statutory obligation upon the employer to pay Provident Fund. If it is not paid in such a way, writ may lie. Because in that case, what the aggrieved person will be asking for is to enforce his right under the Provident Fund Act. Now here in a private employment, what is going to enforce Milord? He cannot enforce Article 311. It's a different matter, Milord. All procedures were followed. She was given an inquiry, so cause, she replied, there was an inquiry report, therefore she was terminated. But at the end of the day, the forum which you have chosen is not the correct forum.
Okay, this petitioner was terminated
Yes.
later on, after DP.
Yes, after DP.
Oh.
After DP, regular DP, we have annexed everything.
Hmm.
But my question is, my lord, end of the day, you are in a private employment.
Wow.
Now, which
You're on
statute?
you're on the maintainability.
Yes,
This is now the forum for
yes,
asserting your right to
yes,
forum
yes.
against
And
that
we-
termination.
Please have section 14 of the specific relief act. my lord.
Yes.
Following contracts cannot be specifically enforced.
Hmm.
Namely, where a party to the contract has obtained substituted performance, we'll skip that. A contract performance of which involves performance of a continuous duty which court cannot supervise. A contract which is so dependent on personal qualification of the parties that the court cannot enforce specific performance of his material terms. A contract which in its nature determinable. Now this will fall under C. A contract which is so dependent on personal qualification of the parties that court cannot enforce specific performance of his material terms. Now, my lord, end of the day, what is the statutory obligation of the Tezpur Law College towards the petitioner? It's a different matter that Article 14 has been complied with in the sense that it is not a case of arbitrary termination. It's a pure and simple case of a departmental action being taken. As the example which I have given, my lord, in an appropriate case, even, my lord, against a private employer also it may lie. If on that private employer, there is a statutory obligation to perform a legal duty. But that is the position in law, my lord. Now, the other judgment which I would like to place, my lord, is that St. Mary's Schools Education Society's case, 2023 4 SCC 498.
Before you read this,
Yes.
can you just have a break for 5 minutes?
My lord,
I'll
I'm so
come back.
sorry. My lord will kindly have the judgment. My lord.
Yes.
Lord will kindly come to page 519 of the judgment for the facts. Para 29.
Yes.
Para 29 at page 519.
Hmm.
Respondent number 1 herein has laid much emphasis on the fact that at the time of appointment in the school, the same was affiliated to Madhya Pradesh State Board. It is his case that at the relevant point of time, the school used to receive grant in aid from the state government of Madhya Pradesh. Later in point of time, the school came to be affiliated to CBSE. The argument of respondent number 1 seems to be that as the school is affiliated to central board, that is CBSE, it falls within the ambit of state under Article 12 of the Constitution. This school is affiliated to CBSE for the purpose of imparting elementary education under right of children to free and compulsory education. As appellant number 1 is engaged in imparting education, it could be said to be performing public function. To put it in other words, the appellant one could be said to be performing with public duty. Even if a body performing public duty is amenable to writ jurisdiction, all its decisions are not subject to judicial review. Only those decisions which have public element therein can be judicially reviewed under the writ jurisdiction. If the action challenge does not have the public element, a writ of mandamus cannot be issued, as the action could be said to be essentially of a private character. So this is the factual background, Milord.
Mm.
Then Milord will kindly turn to page number 522. Para 37. This court in KK Saxena observed as follows. What follows from a minute and careful reading of the aforesaid judgment of this court is that if a person or authority is a state in the meaning of Article 12 of the Constitution, admittedly a writ petition under Article 226 would lie against such a person or body. However, we may add that even in such cases, writ would not lie to enforce a private law right. There are catena of judgments of this court on this aspect, and it is not necessary to refer to those judgments, as it is the basic principle of judicial review of an action under administrative law. The reason is obvious. A private law is that part of a legal system which is a part of the common law, and that involves relationship between individuals, such as law of contract or tort. Therefore, if the writ petition will be maintainable against an authority which is state under Article 12 of the Constitution, before issuing any writ, particularly writ of mandamus, the court has to satisfy that the action of such an authority which is challenged is in the domain of public law as distinguished from private law. It is right that contract of personal service cannot be enforced. Milord, this passage is already quoted in the judgment of Milord State Bank, which I have already referred, Milord. So therefore, I'll skip this portion, Milord. Then Milord will kindly come to paragraph 49 at page 525. Para 49 towards the bottom of the page. We may refer to and rely upon of one order passed by this court in SK Varseni versus Our Lady of Fatima Higher Secondary School, in which the dispute was one relating to retirement age of a teacher working in an unaided institution. Similarly, these are also not unaided, Milord. This court, while dismissing the appeal preferred by the employee, held as under. Both the petitions were dismissed by the single judge on the ground that no writ would lie against unaided private institution and writ petitions were not maintainable. Aggrieved thereby, writ appeal have been filed before the division bench without any result. Division bench held that writ petitions are not maintainable against a private institute. Aggrieved thereby, these appeals have been filed. Now please come to last para 8, Milord. Accordingly, we hold that writ petitions are not maintainable against private institution. There is no infirmity in the order passed by the learned single judge and affirmed by the division bench. These appeals are devoid of any merit and are accordingly dismissed, no cost. So, Milord, this is how different judgments were referred to. Eventually, Milord will kindly come to para 75 at page 537.
One thing, Mr. Chaudhary,
Yes,
you have taken me straight to paragraph 8.
yes.
What was the reasoning given here
Okay.
to dismiss the
Because
SLP?
it is a private institute. Because it is a private institute. I may read it, Milord.
Okay, it's okay. Paragraph 7, public
Yes.
law element is not there.
Yes. It is a
Okay.
private institute.
Hmm.
Milord, only exception as has been carved out the three conditions, Milord. When Article 311 is in fact violated, when Milord industrial standing order is violated, and the third category was Milord when the Milord ID Act is applicable.
Hmm.
Now, eventually, the conclusion which has been drawn in St. Mary's Education Society, Lordship will get at page 537. We may sum up our final conclusions as under at page 537. I'll have your Lordship's kind attention to me, Lord, for 7.75.1, 2 and 3. An application under Article 226 of the Constitution is maintainable against a person or a body discharging public duties or public functions. The public duty cast may be either statutory or otherwise, and where it is otherwise, the body or person must be shown to owe that duty or obligation to the public involving public law element. Similarly, for ascertaining the discharge of the public function, it must be established that the body or person was seeking to achieve the same for the collective benefit of the public or a section of it, and the authority to do so must be accepted by public. Now 75.2 and 3 is very important. Even if we assume that an educational institution is imparting public duty, and the act complained of must have direct nexus with discharge of public duty, it is indisputably a public law action which confers a right upon an aggrieved to invoke the extraordinary writ jurisdiction under 226 for a prerogative writ. Individual wrongs or breach of mutual contract without having any public element as its integral part cannot be recited through a writ petition under Article 226. Wherever court have intervened in their exercise of jurisdiction under Article 226, either the service conditions were regulated by statutory provision or the employer had a status of a state. Kindly mark this word line. Wherever courts have intervened in their exercise of jurisdiction under Article 226, either the service conditions were regulated by statutory provision or employer had the status of state. Here, my lord, the condition of service of the petitioner is not regulated by any statute, my lord. Neither, my lord, the Tezpur Law College is a state or a state within the meaning of Article 12. Yes, my lord, imparting of education is definitely a public function. But, my lord, the duty which is that employer must owe to the employee must be, my lord, emanating from a statute. For example, the example which I have given, supposing, my lord, I am entitled to Provident Fund. If Provident Fund is not given, certainly a petition would lie, as was the case in Andi Mukta's case, 89. Then 75.3. It must be consequently held that while a body may be discharging a public function or performing a public duty, and thus its actions becoming amenable to judicial review by constitutional court, its employees would not have the right to invoke the power of High Court conferred by Article 226 in respect of matters relating to service where they are not governed or controlled by any statutory provision. So, my lord, this is the ultimate nail in the coffin. It says High Court, its employee would not have the right to invoke the power of High Court under conferred by 220 in respect of matters relating to service where they are not governed or controlled by any statutory provision. It's a contract of personal service between the petitioner and the Tezpur Law College. It is not governed by any statute, my lord. An educational institution may perform merit functions touching various facets of public life and in the societal sphere. While such of those functions as would fall within the domain of public function or public duty be undisputably open to challenge and scrutiny under Article 226, the action or decisions taken solely within their confines or confines of an ordinary contract of service having no statutory force or backing cannot be recognized as being amenable to challenge under Article 226 of the Constitution. In absence of this service condition being controlled or governed by statutory provision, matter would remain in the realm of an ordinary contract of service. So this is, my lord, ultimate, my lord, the conclusion. Now, it is not the case of the petitioner that the condition of service is governed by statute. The only, my lord, they have filed an additional affidavit to bring on record some grant given by the government to the college. My lord, government, look, nowadays, my lord, governments are appointing teachers as tutor on a fixed pay. To that extent, my lord, the concept of Article 12 has been, my lord, diluted. Everywhere, my lord, we find contractual service. Actually, my lord, when it comes to government, it cannot engage somebody on contractual service or a fixed pay. Minimum the scale should be given. But my lord, with the change of time, with the change of, my lord, judicial thought process, things are changing. Yesterday, my lord, the Honorable Supreme Court had said, normally, my lord, whenever the trial trial is prolonged, then on the ground of, my lord, continued incarceration, bail was granted. Now, yesterday, the Court of Chief Justice, one we have read in newspaper today, has said that these are all old-fashioned law. Time has come to change it. Now, yesterday, the Honorable Chief Justice of India has said, Lord, that we should not only be concerned with the long incarceration of the accused, we must also think for the victims who are the sufferers of the crime. So therefore, my lord, things are changing. Now though we are a welfare state, my lord, the meaning of welfare state has become a very constricted one. If that be so, my lord, concept like a private institution, such concept like to maintain a writ against a private institution is something, my lord, it is unfathomable. Therefore, my humble submission is, my lord, it's a pure and simple case where a private institution had engaged the petitioner, whereby he was given a fixed pay for whatever good or bad reasons, my lord. The termination was resorted to. Even on merit also, my lord, I find, my lord, there is no infirmity because all the charges have been proved and rightly she has been terminated. But then essentially my argument is, my lord, Tezpur Law College is a private institution. It does not owe any public or a statutory duty towards the, my lord, petitioner to enable him to invoke the writ jurisdiction, my lord. So that being the position, my lord, this writ petition is not maintainable. And going by the spirit of this Special Relief Act, my lord, section 14, he by filing a suit, he cannot get an order of reinstatement also. All that he can do is to pray for damages.
Where is the termination order, by the way?
Yes.
Hmm.
1 second. Yes, 247, my lord. On 21/07/23. Whereas in terms of approval of the governing body, show cause notice bearing so and so based on preliminary inquiry committee set up on Iman was submitted. Its report on 25/2/23 was issued to Srimati Smita Borua Deka. And whereas Smita Borua Deka had given her reply on so and so, the said reply was not found to be satisfactory. An inquiry was directed to be held. And whereas inquiry officer submitted the inquiry report, a copy whereof was duly forwarded to Smita Borua Deka for her comments. And whereas Smita Borua Deka has submitted her representation, posted on so and so, received on so and so, the said representation was placed before the governing body and was not found to be satisfactory. Her representation lacks any fact documented report. And whereas the governing body, upon due consideration of the inquiry report, along with all relevant material allegation charges leveled against this Smita Borua so and so, stood proof and renders her unfit to be continued in service of the college. And accordingly, governing body decided to impose upon Smita Borwa Deka the penalty of dismissal from service on her with effect from 21/7/23. My lord, assuming, my lord, the writ petition is maintainable. Now, considering the factual matrix of the case, my lord, lordships cannot, once there is some evidence, end of the matter. It is not even their case of a disproportionate punishment or something. So therefore, my humble submission is, my lord, even on merits, there is absolutely nothing to interfere in this case. Because charges are proved, unless one can make out a case of no evidence, a 226 court will not go to the extent of finding out, my lord, or reassessing the evidence.
Okay, so
That is my humble submission. Essentially, my lord, I have argued on the maintainability.
right,
That's my humble submission.
all right.
And be clear.
Hmm.
Lordship's kind permission is a matter in court number 1. I may be qualified.
Sure.
Milord, if I may reply,
Yes, Mr. Chamo. All these three writ petitions are by the same person. isn't
same
it?
person.
Why three?
Milord, first I was removed from the post of secretary. Being principal, I was the ex-officio secretary of the governing body.
Hmm.
And without giving any notice, the president removed me from the post of secretary. Then
So
one
what
writ
writ
petition.
petition?
Then again, I was suspended.
Hmm.
Then the second writ petition.
Hmm.
Then I am terminated. Then the third writ petition.
Hmm.
That is your lordship mistake.
Okay,
This includes all the materials that is there in the first 1 and 2. So lordship may take up this only.
all right.
But what I sincerely submit before lordship, my lord,
Hmm.
the first argument advanced by my learned senior friend is that this is a contractual appointment is
Hmm.
not correct. Because of the fact, if lordship can come to page 26 of this binding volume,
Hmm.
page 26.
Yes,
This is the advertisement. If I may read, my lord.
yes.
Tezpur Law College also advertisement for principal. Applications are invited from intending candidates for the post of principal whole time of Tezpur Law College. Candidates fulfilling requisite qualifications and experiences as per norms of Bar Council of India, UGC, may apply within 10 days from the date of publication of this advertisement. Salary will be commensurate with the experience. Now, where is the term contractual appointment? Now, my lord, see the letter of appointment that was read over to your lordship, my lord, by my learned senior friend. That letter of appointment, my lord, does not speak about the contractual appointment. The emolument or the remuneration is a lump sum.
Hmm.
The remuneration that was given to the petitioner was a lump sum remuneration. That by itself, the appointment cannot be termed as a contractual appointment. And if lordships look at the appointment orders, it says this the first 1 year is the probation period. It is unheard of that in a contractual appointment, there will be any probation period, my lord. If lordship, my lord, takes a note of these things. Now, my lord, will kindly see who took the action against me. Who took the action against me? It is the president of the governing body. I have challenged the appointment of the governing body's president, my lord. He is a political person. He is a person who is appointed he is elected as a member of the Tezpur Municipal Corporation, and it is barred. If I can take your lordship to the rules, my lord, of that binding volumes, page 273 is the rules, my lord. I can definitely make a questions to this appointment of the president, my lord, which is parse bar by the rules. So any actions taken by an illegal appointee, fundamentally, my lord, and essentially, has to be struck down by this court. Because they are discharging a public functions and a public duties, therefore amenable to its jurisdiction. All non-government colleges are, my lord, governed by this rule. Page 274, my lord. College means top of the 274, small a. College means a provincialized colleges and non-government college. This is a non-government college. Then, my lord, constitution of the governing body.
Rule 3, my lord, if I may read, my lord. Every college affiliated to any central or state university of Assam duly concurred by the state government shall be governed by governing body. Composition of the governing body shall consist of one president who shall be an eminent person from the field of education. He shall be appointed by the Director of Higher Education and shall have a term of 5 years. He shall, however, continue beyond the period till his successor is appointed. The director may, however, remove him from 5 years of service, so and so. One secretary. The principal of the college shall be the ex officio secretary. Then my lordship will come, his disqualification is at page 276. 3. The president, has your lordship got it?
Yes.
The president of governing bodies of college shall mean an eminent person from the field of education. He shall be a non-political person. He should not have contested any election, including panchayat, municipality, local bodies election, or should not be an office bearer of any political party, or should not have any affiliation membership to any political party. And my lord will kindly come to the next writ petition. One writ petition and annex his result, my lord. Annex the result of his 292, my lordship may kindly take the writ petition 292, my lord.
292.
Page 40, my lord.
Page
40. This is the result of Tashpur municipality election results 2022. Lordship got it?
Yes.
His second name, Dr. Jaishankar Hazarika, Party BJP. Is the election results published by the Assam Municipal State Election Commission. And he said this fact has not been denied by the respondent. Therefore, the very foundational aspect of the matter is, my lord, the person who took the decision is illegally appointed and cannot hold the post of president. So it goes to the very root of the matter, my lord. Now, my lord, so far as the applicability, the private law concern or private law or public law, there's the question raised by my learned senior friend. I'd like to show the one document, my lord, that is page 299, the medicinal affidavit. They have accepted it. There is no dispute in that they have received grant of rupees 3,57,000 in 2013 from the government. Or hereafter also, if they got, I do not know, my lord. The only document I have, I annexed. Therefore,
where's that?
that is it, my lord. In my, here it is page 301.
Of which writ petition?
In 4903. This one, in that. There is an additional affidavit, my lord. Not in the, may not be in the binding volume. Filed by Dr. Smita Borua Deka. That is annexed as Annexer A. The later dated 19th March 13. This is the, my lord, grant they received. Now, my lord, coming to a, let us start from home, my lord. Coming to a judgment of our High Court, my lord, Division Bench. Right, yes. But in these judgments,
This was already supplied last time.
okay.
It's already there.
Given one moment.
Yes.
Well, let me come to paragraph 2 of that judgment. May I read, my lord?
Yes.
The learned single judge dismissed the writ petition on the ground that the fourth respondent is a non-government college not receiving any deficit grants in aid and ad hoc grant in aid, and the college being a purely private non-governmental institution, the writ petition would not lie. the appellant aggrieved by the said order filed his appeal. When the impugned order of termination was passed by the Assam Non-Government College Management Rules 2001 was in force. Here, that the rules I showed to your lordship just a few minutes ago, that is the rule, that is the amended rules of these rules, my lord. The provisions of Rule 133 and 18 of the Assam Non-Government College Management Rule 2001 is extracted here in below for the reference. Then coming to the yes, 1.3. They shall be applicable to non-government college in Assam affiliated by the central or state university of Assam and in respect of deficit grants in aid or ad hoc grants in aid from the state government. So it qualifies with, my lord, it fortifies my claim, my lord. The constitution of the governing body that I have read now, my lord, this rule was amended in 2009, my lord, that I have shown just your lordship. So coming to the paragraph 5, my lord, below. Rule 1.3 of the Rules 2001 declares that the provisions will apply to only to non-governmental colleges affiliated to any central or state university in Assam and which are in receipt of the deficit grants in aid or ad hoc grants in aid. They got an ad hoc grants in aid from the state government. In this regard, the learned single judge found that the college in question is not receiving any deficit grants in aid or ad hoc grants in aid. Par contra, the counsel for the appellant relies on the order of the additional Director of Education, Karbi Anglong Autonomous Council, dated so, which discloses that from 147 to 39 2007, the college of the fourth respondent has received an ad hoc recurring grant of rupees 3,50,000. In our case, my lord, is 3,57,000. Yes, 3,57,000. The counsel for the respondent appellant also refers to para 5E of the affidavit of the respondent of 5, which discloses that the college has been receiving ad hoc grants and been using the same for overall development of the college and providing infrastructure facilities to the students in the college. It is also stated that ad hoc grants are not sanctioned to manage the affairs of the college, and the college authority has been observing laws in force and administering all the affairs of the college within the framework of the established and administrative principles. Now, my lord, the important paragraphs are paragraph 15 and 16. This is the ratio decidenda, my lord. Paragraph 15. Upon thorough consideration of the facts and submissions, we find that the affidavit filed by the fourth respondent in the writ petition and the order of payment of ad hoc recurring grant by the Karbi Anglong Autonomous Council clearly disclose that the ad hoc grants in aid has been given to the college in question. Therefore, by virtue of Rule 1.3, the provisions of the Assam Non-Government College Management Rules 2001 would apply to the facts of the case. The provisions of Rules 133 and 18 discloses that nature of government control in constitution of governing body and control over the functioning and management of the college by the governing body. This is the deep and pervasive control that my learned senior friend was referring to. The government has substantial control over the functioning of the college and has been giving ad hoc grants in aid. The appellant availed of the maternity leave. The view taken by the governing body that the maternity leave granted are 90 days and she has overstayed, therefore she is removed is incorrect. When the maternity leave is 135 days, the fourth respondent cannot curtail the benefit of maternity leave to 90 days and hastily terminate the services by perfunctorily issuing the so cause notice. These are the other facts of the case, my lord. Now, my lord, my lord, this one more judgment that I'd like to show to your lordship, my lord, if it is there, my lord, 2015-16 SCC, Janet Jayapal versus SRM University of Address. This is also a private university. Is it there, my lord? If not, then I have a copy, my lord.
Just a minute. Name of party?
My lord, Janet Jayapal versus SRM University and others. 2015-16 SCC 530.
Yes, J. Paul is there. Paragraph.
Paragraph, my lord, page 532, my lord, paragraph 3 onwards. SRM University, respondent 1 herein is the institution engaged in imparting higher education in various subjects. The central government has therefore, on the advice of the UGC, declared respondent 1 as deemed university by issuing a notification under section 3 of the UGC Act 1956. Respondent 1 is therefore subjected to ensuring compliance with all the provisions of the UGC Act in its functioning. Here, my lord, in compliance of the UGC regulation, the advertisement mentioned that the qualification should be in accordance with the UGC regulations. If lordship can relook at the page 26. This is the ingredients of deep and pervasive control of the state. Page 26, if lordship can look at, the advertisement says that the qualification should be as per the UGC regulations and Bar Council and UGC regulations. Both the statutory bodies.
Yes.
The appellant is holding MSc and PhD in applied biology. She was appointed as lecturer in the Department of Biotechnology in the Faculty of Sciences and Humanity in SRM University. Respondent 1, SRM University Respondent 1. By order dated 5/5/2010, she was promoted as senior lecturer with effect from 1/4/2010. On 14/2/2012, the appellant was served with a memo calling upon her to show cause as to why disciplinary action should not be taken against her for the alleged failure to take classes of the students of BSc third year degree course and MSc first year degree course. The appellant submitted her replies on so and so date to so and so date, denying the allegations and claiming that she took classes for both the courses. Thereafter, another memo dated so and so was issued by the registrar in charge of the university, referring certain complaints given against her by the students. Refuting to the charges, the appellant submitted her reply on so and so date. Dissatisfied with the explanation given by the appellant, Respondent 1, SRM University constituted an inquiry committee and the appellant appeared before the said committee on so and so date and stated that she was not furnished the documents and the copies of the complaints. Thereafter, she submitted a detailed explanation on so and so date. Thereafter, the appellant received a notice on so and so date mentioning therein that the same shall be treated as 1 month's notice and she would be relieved from service from so and so date. According to the appellant, she received the notice on 16/4/12. This is, my lord, this shows that this is absolutely a private, absolutely a service dispute between the university, which is a private university, and the employee. Kindly come to page 536, paragraph 25. This Andi Mukta case that your learned senior friend showed to your lordship, also here also it is discussed. It is not par incuriam. It is discussed here. The question, the Andi Mukta case, the question before this court arose as to whether mandamus can be issued at the instance of an employee against a trust registered under the Bombay Public Trust Act 1950, which was running an educational institution. The main legal objection of the trust while opposing the writ petition of their employee was that since the trust is not a statutory body and hence it cannot be subjected to the writ jurisdiction of the High Court. The High Court accepted the writ petition and issued a mandamus directing the trust to make payments towards the employee's claim of salary, provident fund and other dues. The trust appealed to this court. This court examined the legal issues in detail. K. Jagannath Shastri, Justice speaking for the bench, agreed with the view taken by the High Court and held as under. Two questions, however, remain for consideration. That is, liability of the appellants to pay compensation under Ordinance 120E. Two, the maintainability of writ petition for mandamus as against the management of the college. Squarely covered in our case. The essence of the attack on the maintainability of the writ petition under Article 226 may now be examined. It is argued that the management of the college, being a trust registered under the Bombay Public Trust Act, is not amenable to the jurisdiction of the High Court. The contention, in other words, is that the trust is a private institution against which no writ of mandamus can be issued. In support of the contention, the council relied upon two decisions of this court. A. Vice Degree College versus Lakshmi Narayan, and Deepak Kumar Biswas versus the Director of Public Instruction. In the first of the two cases, the respondent institution was a degree college managed by a registered cooperative society. A suit was filed against the college by the dismissed principal for reinstatement. Same case, Milord. Dismissed principal herein also. It was contended that the executive committee of the college, which was registered under the Cooperative Societies Act and affiliated to Agra University, was a statutory body. The importance of this contention lies in the fact that in such a case, reinstatement could be ordered if the dismissal is in violation of a statutory obligation, but this court refused to accept the contention. It was observed that the management of the college was not a statutory body, since not created by or under a statute. It was emphasized that an institution which adopts certain statutory provisions will not become a statutory body, and a dismissed employee cannot enforce a contract of personal service against a non-statutory body. If the rights are purely of a private character, no mandamus can issue. If the management of the college is purely a private body with no public duty, mandamus will not lie. These are two expectations to mandamus, two exceptions to mandamus. But once these are absent, and when the party has no other equally convenient remedy, mandamus cannot be denied. It has also to be appreciated that the appellant's trust was managing the affiliated college to which public money is paid as government aid. Public money paid as government aid plays a major role in the control, maintenance, and working of educational institution. The aided institution, like government institution, discharge public function by way of imparting education to students. They are subject to rules and regulation of the affiliating university. Their activities are closely supervised by the university authorities. Employment in such institutions, therefore, is not devoid of any public character. I'll let me note it below. So are the service condition of the academic staff. When the university takes a decision regarding their pay scales, it will be binding on the management. The service condition of the academic staffs are therefore not purely of a public character. Purely of a private character. It has superadded protection of by university decision, creating a legal right due to relationship between the staff and the management. When there is existence of this relationship, mandamus cannot be refused to the aggrieved party. And 27, Milord. That paragraph 20 also above the 27, Milord, is quoted from the previous judgment. This is also important. The term authority used in Article 226 in the context must receive a liberal meaning, unlike the term in Article 12. Article 12 is relevant only for the purpose of enforcement of fundamental rights under Article 32. Article 226 confers power on the High Court to issue writs for reinforcement of the fundamental rights as well as non-fundamental rights. The words any person or authority used in Article 226 are therefore not to be confined only to statutory authorities and instrumentalities of the state. They may cover any other person or body performing public duty. The form of the body concerned is not very much relevant. What is relevant is the nature of the duty imposed on the body. The duty must be judged in the light of positive obligation owed by the person or authority to the affected party. No matter by what means the duty is imposed, a positive obligation exists, mandamus cannot be denied. This issue was again examined in great detail by the Constitution Bench in G. Telefilms versus Union of India, wherein the question which fell for consideration was whether the BCCI falls within the definition of state under Article 12 of the Constitution. This court approved the ratio laid down by the Andi Mukta case, but on facts of the case held by majority that BCCI does not fall within the purview of the term state. This court, however, laid down the principle of law in para 31 and 33 as under. Be that as it may, it cannot be denied that the board does board does discharge some duties like the selection of an Indian cricket team, controlling the activities of the players and others involved in the game of cricket. These activities can be said to be akin to public duties or state functions, and if there is any violation of any constitutional or statutory obligation or rights of other citizens, the aggrieved party may not have a relief by way of a petition under Article 32, but does not mean that the violator of such right would go scot-free merely because it or he is not a state. Under the Indian jurisprudence, there is always a just remedy for the violation of a right of a citizen. Though the remedy under Article 32 is not available, an aggrieved party can always seek a remedy under the ordinary course of law or by a writ petition under Article 226 of the Constitution, which is much wider than the Article 32. Thus, it is clear that when a private body exercises its public functions, when if it is not a state, the aggrieved person has a remedy not only under the ordinary law, but also under the Constitution by way of a writ petition under Article 226. It is clear from a reading of the ratio decidendi of the judgment in G. Teleflame that firstly, it is held therein that BCCI discharges public duties, and secondly, an aggrieved party can for this reason seek public law remedy against BCCI under Article 226 of the Constitution. Applying the aforesaid principles of law to the facts of the case in hand, we are of the considered view that the division bench of the High Court erred in holding that respondent 1 is not subjected to the jurisdiction of the High Court under Article 226 of the Constitution. In other words, it should have been held that respondent 1 is subjected to the jurisdiction of the High Court under Article 226 of the Constitution. Thus, we say for the reasons that firstly, respondent 1 is engaged in imparting education in higher studies to students at large. Secondly, it is discharging public functions by way of imparting education. Thirdly, it is notified as a deemed university by the central government under section so and so. Fourthly, being a deemed university, all the provisions of the UGC Act are made applicable to the respondent 1, which inter alia provides for effective discharge of the public functions, namely education for the benefit of the public. Fifthly, once respondent 1 is declared as a deemed university, whose all functions and activities are governed by the UGC Act, alike other universities, then it is an authority within the meaning of Article 12 of the Constitution. Lastly, once it is held to be an authority as provided in Article 12, then the necessary consequences it becomes amenable to this jurisdiction of the High Court under Article 226 of the Constitution. In the light of the foregoing discussions, we cannot concur with the finding rendered by the division bench, and accordingly, while reversing the finding, we hold that appellant's writ petition under Article 226 of the Constitution against respondent 1 is maintainable. And perhaps in my respectful understanding, this is the clear-cut findings which squarely covers my case. Going to the very root of the matter, my lord, that the person who is the center figure of all the allegations that I have leveled against him here is a appointee whose appointment itself is wrong. Therefore, my lord, all actions goes, my lord.
So Mr. Chama will come back at 2.
My lord, one accommodation, if lordship allows me, my lord, I am going to Dhemaji sometime, my lord. If lordship then, my lord, takes it up on 1st or 2nd of May, my lord, whenever possible, my lord. I'll continue then. Anyway, my lord, 1st of May, perhaps holiday. So, my lord, on 4th of May, my lord, if not inconvenient.
11th of May.
Or 11th of May. But as per their convenient, I am here very much available in that case.
May I accommodate us lordship because it will be not their lordship for the first week lordship. Had it been lordship Friday, one day is open with a fixed on Friday, but there's some, we have to return from Dhemaji also.
Huh.
Second half, you're not there today.
30th, I am here, my lord.
Second half, you're not there.
Sorry, my lord, I have to leave, my lord. It's 500 kilometers away from here. Even if I start now, my lord, I will reach at 11 or 12 o'clock at night.
So anyway, that will,
30th of April is no problem. my lord.
no, 30th of April will be difficult.
Thursday is okay.
Kindly accommodate, my lord, because there is a preoccupation that I cannot avoid it. my lord.
Thursday, I'm okay, Lord.
Hmm.
Thursday. Thursday, go fine.
Thursday কি বার?
This
কি-
Friday.
আমার পারি বসে পড়বেই হবো। হ্যাঁ, হয়ে যাবে কেস।
Thursday is 30th.
হ্যাঁ,
30th. That is day after tomorrow.
or if not inconvenient for my lord, your lordship, my lord, 4th of May, my lord. কোন তারিখে পার এটা?
12th of, 12th.
Or 12th of May. I'm to here, my lord, no issue.
What is the situation? Just on 30th, 15. 5th. That matters. Hmm?
7th I'm here, my lord, no problem.
7th, another part 30 day.
Good night, my lord. My lord, they have completed their part. Just I have to point out 2-3 things, my lord. On 7th, if they are not having any inconvenience, on 7th, lordship may take it.
So far, it's on the maintainability
Yes, yes, yes.
only.
That is why, my lord.
Maintainability.
That is only.
We'll do one thing, we'll try it on Thursday,
Yes.
30th.
I have nothing more to say, my lord. Just 2-3 points from the inquiry report. That's it.
Right. List again on Thursday.
Tell me this, Lordship, just to report back.
List again on Thursday,
30th,
Yes.
my lord.
as paid for by the parties. 30th. Yes.
Small request, my lord. I'm sorry for this untimely request because I have to attend the funeral at 2 o'clock.
Which one? Which matter?
Item 23, my lord.
Yes, what do you want?
Just accommodation for the day. So, my lord, if, can we have a try on 7th of May?
Have you informed the other side?
Yes.
I don't know. See, on the request of Mr. J. Abidin, Learned Counsel for the respondent, private respondent,
Yes, my lord. 4.
respondent number 4 and not objected to by the other side. Let the matter be listed. When can we have it? 2 weeks.
7th, can we have
Give a
try?
date, which date? 14th of May.
14th of May.
Yes.
After it, no. Try it at the moment. My lord, could we have a try on 7th? Because
There are many matters on 7th.
I've
That is
taken
why.
a side request. That is the one who.
I know, but the thing is that there are many matters on 7th.
Okay.
That is why.
Deeply obliged, man.
Lordship, here in this matter, Lordship, this morning I have filed an affidavit, but we have served a copy and we have filed our affidavit this morning, Lordship.
What affidavit? Counter affidavit?
Yes, Lordship.
I will receive the copy.
Yes, my lord, we have.
Mr. Dew Permanent Learned Counsel for the Higher Education Department submits that the counter affidavit has been filed by the department this morning. So Mr. J. Payang, Learned Counsel for the petitioner, submits that he has received a copy of the receipt. In view of above, list the matter. When?
On 11th, my lord.
11th.
11th.
Any,
Because, my lord, we have some urgency because already 4 years. Every time. Otherwise, your lordship can dispose of on that day, my lord. I think, don't think. 25.
on 25, 26.
It's on behalf of P. Hazarika for respondent number 5.
Can it be prior to 25, 11 to 18? 18.
You got the name?
Yes, 18.
Respond number 5.
No,
Miss B. Thakuria, Learned Counsel appears on behalf of P. Hazarika, Counsel for respondent number 5.
Obliged.
On 18, huh? List on 18.
18 is.
My lord, can it be taken after some time, my lord? The council is in another court, my lord.
Okay, time being.
Please, your lordship. Lordship, in this case,
Yes.
it is. My lord, here petitioner was appointed as headmaster and he joined his service on 2/1/1995. And private respondent number 6 joined on 9/1/1995. And private respondent number 7 joined on 10/1/1995. So my lord, petitioner is the senior teacher of the school, being a headmaster, and he taught language subject, English language, in addition also for social science also. My lord, so being respondent number 7, he taught Assamese. So my lord, I like to take my lord, page 29.
Yes, you are there for the
I am for the private respondent, respondent number 6 to 8,
6 to 8.
my lord.
Okay.
Admittedly, he is senior.
That is my case.
Admittedly, he is senior.
Okay.
But the fact is that, my lord, so far the subject is concerned, my lord. So he, being the headmaster, my lord, he did not tell the language teachers, my lord. And then, my lord, in earlier round of litigation, my lord, that can be seen while he filed the earlier petition, another petition, my lord. So there he claimed that he used to teach, my lord, English, but subsequently he diverted his, my lord, plea, and then in the present round of litigation, my lord, he is saying that no, he used to teach social science as well. So that part was not there in the earlier round of litigation. And more importantly, my lord, if your lordship is pleased to peruse Annexure 16 of the writ petition, my lord. So there is an appeal filed by the petitioner. So that appeal is pending.
Appeal before?
Appeal before the, my lord, the commissioner and the secretary.
That is not mandatory. I have already filed Adan 14.
Because
That has
not-
been decided.
As per
So
the,
let
as
me
per
my
section
place my
14, my
case.
lord, when he himself preferred an appeal without knowing the outcome of the appeal, my lord, because that was preferred by him. And he has made a statement and has also annexed the copy of the appeal, my lord. So we do not know the status of the appeal, whether that has been decided or not.
Not
So
necessary. my lord.
on that count, my lord. So the appeal was filed earlier. That is yet to be disposed of. So by that way, my lord, he cannot place his case before this honorable court.
Okay, okay, we'll hear the matter.
My lord.
Okay.
My lord,
we'll-
let me.
Yes.
Now,
my case.
What about the department? You are there?
My lord, we have not filed our affidavit here. We have prepared our affidavit, but we have not filed.
You have not filed.
Not filed.
Who has filed then?
My lord, we have challenged the provincialization of private respondents. They are all the respondents they have filed.
Affidavit of the department will be required, my lord, because so far the seniority petition is there.
No,
So
seniority
that
is clear from
That
the
is not there in the Act of 2017, my lord. The Act of 2017 nowhere speaks of the provincialization of services on the basis of seniority merely, my lord.
My lord, my submission, my lord, let me place my case first, my lord.
No, before that, why affidavit is not filed by the department? It's basically,
Is it dispute between the parties, my lord?
maybe,
Maybe, yes.
what is the stand of the department that we have to know also?
My,
We have prepared, my lord, we have sent it for vetting, my lord.
When can you file it?
After 10 days, my lord.
10 days.
10 days. Within 10 days, I will file.
Please write, although the petitioner and the private respondents have exchanged their pleadings, the Department of Elementary Education has not yet filed their affidavit in opposition. Mr. P.K. Bora, Learned Standing Counsel. Elementary Education submits that the affidavit has been sent for vetting by the department. And therefore, he prays that he may be given 10 days time to file the affidavit. Prayers allowed. List again on so and so. 85.
obliged,
Department to file their affidavit in the meantime.
obliged.
And
My lord, I am appearing on behalf of Mr. S.K. Das. This matter is fixed for filing of the affidavit, which is supposed to be filed.
We have already filed our affidavit, my lord, but there is additionally an additional affidavit we have to file. Bringing on record certain, my lord, facts, my lord. That, my lord, we are awaiting from the office of the DEO, my lord. So I therefore seek some more time, my lord.
What is this letter?
This is the, my lord, letter given by the directorate to the DEO. To basically clarify the stand on the last occasion, your lordship had given a direction to bring in on record certain things, my lord. We have already filed an affidavit in opposition in this matter. Diligently, my lord. Only an additional affidavit was supposed to be filed regarding whether his science graduate pay scale, whether he, my lord, is entitled or not. In that case,
How much
my lord,
time? How much time?
2 weeks, my lord.
On the prayer of Mr. A. Fukan, Learned Standing Counsel. Education, Elementary Education Department. Further 2 weeks time is granted to file additional affidavit in terms of the order dated 1/4/2026. List again on so.
Obliged, Your Honor.
30.
May I appeal? Lord, respondent number 13, sorry, my lord, respondent number 7 has filed affidavit today. So we need, my lord, 3 weeks times to counter the affidavit.
Okay, please write. Mr. M.E. Mondal, Learned Counsel for the petitioner submits that he has received an affidavit in opposition filed by the respondent number 7. And he prays for 3 weeks time to file a reply affidavit to the same. Praise allowed. List again on so and so.
Deep blood blessings.
40.
May it please your lordship. Lordship, this matter pertains to an recruitment process which was floated by the state of Assam. And subsequently, lordship. But also one thing I'd like to point out, the state is yet to come up with their reply. On last occasion also, 27/3/2026, the lordship kindly peruse the last order. 27/3/2026. My learned friend prayed for further 4 weeks time. It's a matter of notice was issued on 11/3/25.
3/11.
No, I have a
3/11.
instruction today.
Not
only, my
11/3.
lord. Yes, only today I have received the instruction here, and here my lord, appointment letter already issued to the candidates here. And here all the documents are verification was done. And thereafter, the appointment letters to the selected candidates was issued on 13/11/2025 and 20/11/2025, 3/12/2025 and 20/12/2025. So recruitment process regarding the advertisement published on 27/12/2023 is over.
4 posts are to be kept reserved as per the order
Yeah.
of this court.
That was the order.
There's an interim order.
Yes, Your Lordship.
Yes. Regarding that instruction, I have not received that instruction, madam. So, madam, sometime may be granted so that I can clarify all this matter.
What my learned friend is submitting, he's saying that the posts are filled up, but on the very first day when the notice was issued, there was an interim order passed. We have submitted the copy. Now the reason here is what has happened in this case, Your Lordship will. There are two lists. They have published two lists. One is a final final merit list, and then a revised merit list. We came before this court saying that there cannot be two lists. And that is how the interim order was passed.
Mr. U. Sharma, Learned Standing Counsel, Secondary Education Department, submits that he has not received the instructions as yet, and he prays for further 3 weeks' time. Prayers allowed. List again on so and so.
50.
Oblige, Your Lordship. Lordship, similar matters,
15 also similar.
same matter, same date.
Same order.
Oblige, Your Lordship.
Some time may be granted, we have not received the instruction yet, at least 2 weeks time got required.
But earlier several occasions they took time for affidavit.
Yes.
And for external folders.
Are you filing anything?
Well, basically we are to former exponent. We do not have any role in legacy. He has obtained a degree from the university.
Parties are represented by the respective counsels. Mr. A.R. Tahvildar, Learned Counsel appearing for the Higher Education Department, prays for further 3 weeks' time. The file contract with him, prayers allowed.
The last chance may be given, Lordship,
List
because
again on so and so. You wait for some time, we'll see. You fight the affidavit soon.
17.
May I please, your lordships.
Yes.
Lordships, in this matter, I am appearing for the respondent number 3. As in this particular matter, the petitioner is praying for UGC scale of pay from the government on the ground that he has obtained a PhD from Singhania University in the year 2016. A similar matter has already been dismissed by a coordinate bench of this honorable court by judgment dated 23/4/2026, but the said judgment has not yet been uploaded on the internet. So I pray that this matter may kindly be fixed on some other date so that I may be able to produce that particular judgment before this honorable court. In fact, 3 similar matters have been disposed of
And
by the
appears
said judge.
for the petitioner when the matter is called. Your good name, Miss?
Dr. P. Agarwal,
Dr. P. Agarwal, Learned Counsel, appearing for the UGC respondent.
UGC.
Standing Counsel UGC, appearing for respondent number 3, submits that a similar matter has been disposed of by a coordinate bench of this court. And therefore she may be, and therefore prays that she may be allowed to produce the same for the next court date. In view of above, list the matter again on search. Give it.
28.
29. 17.
Lordship, she is appearing for the petition.
I am appearing on behalf of the petition.
So we'll have it on that day. She says that there's a judgment has been passed in a similar case. So we'll see that. Your good name?
R. Begum.
Ms. R. Begum, Learned Counsel, appears for the petition. Okay. Next.
Any date fixed?
29/5.
Of license. Item 21.
Yes.
My lord, that matter again,
Which matter?
but that Dibrugarh University, the petitioner removed from service. And then this is the fifth occasion round of litigations we came. My lord. Last time I made argument about an hour.
Who's for the university?
My lord, he was just now, he was here. He was
Who's
just now, he was here. Probably will be coming.
Who's the counsel?
Dr. Mr. Gogoi, Kosto Gogoi. He was here just now. He was here.
Here, Kogo. Service matter.
Service matter, my lord. She was an engineer in the Dibrugarh University. And then she was, for certain reasons, suspended. We came before the Honorable Court. She was reinstated, again suspended, again reinstated, again removed, again reinstated. Again, my lord, there's a proceeding. Again, she was removed. This is the fourth or fifth occasion. We are before your lordship, my lord.
So you are spending your entire service career in litigation.
Oh, my lord, what to do? They compelled me, my lord. And while the case is pending, she was fighting so much, and then she's retired also, my lord. And
What good works have you done
my lord,
to deserve this?
my lord, pardon.
What kind of work have you done?
My lord, lordship will
Sir.
find, my lord. Lordship will find, my lord. If your lordship come to page number 228, because pursuant to the court's order, my lord, it starts from page number 228.
No, are we hearing the matter today or not?
If your lordships feel, I leave to your lordships, my lord. If your lordships feel it today, or if your lordships any other day, my lord, I leave to your lordships, my lord.
Is it a short matter?
No short matter. It will take at least take time. It will take time because last occasion I, your lordships, I argued 1.5 hours.
Okay.
Then lordship was not here. Lordship told us that your lordship will only for about a month. Lordship won't be here. So lordship did keep it part hard. So went it before another court, my lord. That's why it will take around, from my side, it will minimum 1 hour. And my lord, and also will take.
Records will be required also?
Records.
If records is required, then lordship may after 1 week, my junior colleague is in the Chennai lordship did a treatment of his body. That is the junior Chennai.
My lord, my
Lordship may, then lordship may poster after 10 days lordship.
in that case, the date may be fixed.
10 days.
It is better that records are there.
My lord.
We have the records lordship. We have the records lordship, but records kept by my junior lordship.
I see. I see.
Let him come back from Chennai.
She will.
Okay.
Let us be reasonable, my lord.
Lordship.
Okay, as agreed to by the parties, let the matter be listed for hearing on so and so. 21.5.
Date, anything?
21.5.
21.5.
25, my lord.
Mr. K. Gogoi, learned standing counsel. Dibrugarh University shall also produce the relevant records
Lordship, I'll do.
for perusal of the court.
I'll do. Lordship.
My lord, today's camera is not here today. It's such a great relief. Your lordship won't believe, my lord.
Where is it?
Okay.
Pleasure, lordship.
May I appreciate it.
Yes.
Lordship, 24, your lordship. Matter pertains to provincialization of your lordship. These two petitioners of walking in Catholic Mission ME schools, your lordship. Now, your lordship, if your lordship kindly come to page number 20, your lordship.
Why are these two matters clubbed together?
Two matters, your lordship, for the same organization, so same school, your lordship.
Same.
Because, yes, your lordship, same school, your lordship. One ME school, one LP school is there, I think, in the next matter, your lordship, connected matter, your lordship.
You are there in the other matter also.
Yes, your lordship. No, I am not there, your lordship.
In the second matter.
Second matter, your lordship,
I am for the respondent.
respondent.
8 to 11.
I think petitioner side is,
Petitioner in item number 25 is not there.
I think, otherwise the long pending matter, it's going on since 2013, your lordship.
Who's the counsel?
Mr. Alam has been shown as
G. Alam.
cause list, your lordship.
Mr. P.D. Nair, G. Alam, all those, they are there.
I met him outside, man. He said that his junior will be remain, man.
Sorry?
I met him outside of the court, man. He said he will be,
Your junior will be
his
there.
junior will be remain present.
Junior means who? Alam.
One.
Who will come? G. Alam.
His junior.
No, who's that person who's going to appear for the second case?
G Alam.
G. Alam.
In first matter, matter, this is not.
Otherwise, will not take much time, Your Lordship. Yeah, precisely the matter is that, Your Lordship, our name and along with the name of the school has been recommended for provincialization, Your Lordship. Now, during that time, Your Lordship, the process got stuck because of the filing of the next matter, Your Lordship. Some of the teachers from the same campus, Your Lordship, filed the next petition, Your Lordship, claiming their senior, Your Lordship, but not against me, Your Lordship.
There are two petitioners in your case.
Here I'm two petitioners, Your
Two
Lordship.
petitioners.
Two petitioners, Your Lordship.
Your prayer is for provincialization of
Provincialization of the service of the tier.
You're teaching in what subject?
Science and, Your Lordship. Otherwise, my name is there, Your Lordship. Kindly come to page number 20, Your Lordship. If Your Lordship kindly see the 30th column, last column, Your Lordship. My name is second Pranjit Hajorika, Your Lordship. Again, Your Lordship, the petitioner number 2 is Sopan Kumar Biswas, Your Lordship. He's a science teacher, Your Lordship. I am the assistant teacher, the first one, Your Lordship.
You're Pranjit Hazarika.
Yes, Your Lordship.
Assistant teacher.
Assistant teacher, Your Lordship.
And
If you
teaching
should
what?
kindly come down.
Teaching what?
He's for, Your Lordship, the Sopan Kumar Biswas, Your Lordship.
No, the petitioner.
Yes, Your Lordship.
There are two petitioners, isn't
Two
it?
petitioners, Your Lordship.
Petition number 1 is Pranjit Hazarika.
Yes, Your Lordship.
And the other one?
Other one is Sopan Kumar Biswas, Your Lordship.
Sopan Kumar Biswas.
Yes, Lordship. He's a science teacher, Your Lordship. His name is there, Your Lordship. Page number 20, Your Lordship. The last column, Your Lordship. Lordship will.
And others are the matter respondent of the.
Yes, Your Lordship.
Sorry?
Others, matter one, Irenaeus Lakra, Ranjit Hajarika, Shankar Roy, and one Benedicta matter. They are the respondent in other matter.
In the next matter, Your Lordship.
Respondent number 8.
So that is why this both matter has to be heard
Yes,
together.
yes, Your Lordship. We got stuck, Your Lordship, in this case because
Main prayer was the.
there is no seniority claim against me. There is seniority claim. There is claim against those, the other rest of the respondent, Your Lordship.
Petitioner of
The petitioner is there, Your Lordship.
You are there? Which case? 25. You're ready with the matter? So tell me the facts of the
Yes,
case.
Your Lordship. Now, what happened, Your Lordship, in that matter after filing that 339023, Lordship?
So you start from the beginning, facts of the case.
Yes, Your Lordship.
Who are you? And
I
how
am the
you are
teachers of the
appointed?
Catholic Mission ME School, Your Lordship.
Sorry?
Catholic Mission ME School, Your Lordship.
Catholic Mission.
ME School, Your Lordship.
Yes.
Now, Your Lordship, my school, along with the service of the petitioners, Your Lordship, recommended for provincialization. Lordship will already find it out at page number 20, Your Lordship.
20.
Yes, Your Lordship. But there is no administrative order, Your Lordship.
No, where is the beginning of page 20? It's just like that. This is a
Yes,
chart.
yes, Your Lordship. That is the online, Your Lordship, downloaded from Your Lordship website, Your Lordship.
Who has prepared this chart?
Yes, Lordship.
Who has prepared this chart? Where is the beginning? Where is the end?
Director of Elementary Education, Your Lordship.
No, where is the beginning and where is the end? It starts from serial 25, ends at 31.
So you have downloaded it from, Your Lordship. It's published in online, Your Lordship, official website, Your Lordship.
Maybe.
Lordship.
At the top of the corner, my lord, it's a first one 20.
Supposing you take this book.
Lordship.
Take
Yes,
this
I
book
got your point, Your Lordship.
and you just Xerox one, page 577 and annex it there.
Lordship.
How do you know what is this?
It was
From where you've got it?
list, Your Lordship, published by Director of Elementary Education. Your Lordship.
Maybe, but at least you should take care to publish to print the beginning, the index, the reference. To know that what is what.
Otherwise, that is not administrative order, Your Lordship. It will come like this, Your Lordship.
Serial numbers are counted from 1. It begins from 1.
1, Your Lordship.
Your annexus starts at page
25.
at serial number 25.
25, Your Lordship.
So we don't know what is 25. At least the column should be defined from the first page. This is the problem, you see. You're supposed to convey this thing to the court for the court to understand and
Lordship.
analyze and may pass a decision. But if you start from some middle of the page, it becomes very difficult.
Lordship, the
What
recommended
is annexure 1? What is annexure 1?
There
It
is
should
annexure
be-
1, Your Lordship.
I think you should read paragraph 5. You should explain what is annexure 1. First thing first,
Yes, Your Lordship.
you are appointed
Yes, Lordship.
as an assistant teacher,
Yes, Lordship.
uh, Catholic Mission ME School, Salna.
Son.
When were you appointed?
It was in, Your Lordship, 15 February 1993. That is paragraph number 2, Your Lordship. And
15
petitioner number 2
1990.
joined as science teacher on dated, Your Lordship, 5 February 1997, Your Lordship. That is paragraph number 2, page number 5, Your Lordship.
One was what? Appointed as what?
Assistant teacher, Your Lordship.
Any subject,
No, Your Lordship.
just like that.
Assistant teacher, Your Lordship.
General.
He has been,
You
yes,
teach
Your Lordship.
anything.
General, Your Lordship.
You teach anything, whatever comes your way.
Yes, Lordship.
Huh? Where is your appointment order? It's not there also.
It is not there, Your Lordship. Because my name is there, Your Lordship. So
So how do you intend to convince the court?
otherwise, there is, Your Lordship, with due respect, there is no dispute from the
That is not the
concerned
question.
authority, Your
That is not the question.
Lordship.
Merely because there is no dispute, you'll not annex anything. How do you tell bedtime stories once upon a time? Or you start by saying the end? You have to go systematically.
Yes, Lordship.
I am so and so. I was appointed on this date. This is my appointment order. Secondly, number 2 was appointed like that. Both of us are teaching since that day. Then, as per this provision, there's a provision wherein the teachers can be considered for provincialization. I have fulfilled the criteria. This is the recommendation or this is the schedule prepared. Kindly go like that step by step. We are a bit slow in understanding. You may be very fast. What to do? I am very slow. So number 1 appointed assistant teacher.
Yes, Your Lordship.
Number 2 also appointed assistant teacher.
It's a science teacher, Your Lordship.
Science teacher.
Science teacher, Your Lordship.
See, you are very precise about number 2.
Yes.
Number 1, you don't say anything about him.
Assistant teacher, Your Lordship.
Science? No.
No, Your Lordship.
Arts? No.
No, Your Lordship. He's an assistant teacher, Your Lordship. His name has been recommended against assistant teacher, Your Lordship. No subject is there, Your Lordship. Even if Your Lordship kindly 20 also says that to Your Lordship. So he has been appointed as
Okay. Assistant teacher, science
Lordship.
teacher, thereafter.
Thereafter, he's a science teacher, Your Lordship.
This was in which year?
It was, Your Lordship,
93.
93, Your Lordship. One is 97, Your Lordship. The petitioner number 2 is 97, Your Lordship.
97, 93,
97,
97.
Your
Okay, then.
Now, after it, Your Lordship, their service, Your Lordship, has been recommended, Your Lordship. The school has been recommended for provincialization.
What was the school like? What was the school?
It was Catholic Mission ME School, Your Lordship. There are three schools, Your Lordship, in the same campus. One is ME School, one is high school, one is LP School, Your Lordship. The other two schools has already been provincialized, Your Lordship.
It's a private school
Private school, Your Lordship.
and not provincialized.
It was recommended, Your Lordship. It got stuck there only, Your Lordship.
Recommended by whom?
It's a Director of Elementary Education, Your Lordship. It
Under what provision?
was under 10, Your Lordship.
Hmm.
Yes, Lordship. Section 10, Your Lordship. Subsection 4, Your Lordship. The Assam Venture Educational Institution Act 2011, Your Lordship.
Has been
The
struck
district-
down.
Yes, Lordship.
11 is struck down.
Has been struck out, Your Lordship. The new act.
So now what happens?
Your Lordship, at that time, Your Lordship, because it is a list of 6 March 2013, Your Lordship. After that, Your Lordship, some teachers from the same campus, Your Lordship, has preferred a petition that is the next item, Your Lordship, 25, Your Lordship. Because of the filing of that petition, Your Lordship, and the school comes under Article 30 of the Constitution, Your Lordship, the matter got stuck, Your Lordship. We don't get the order, Your Lordship, order of provincialization, Your Lordship. Here, Your Lordship, if Your Lordship kindly see, Your Lordship, the judgment of the next item, Your Lordship, that is 25, Your Lordship.
No, don't take me here and there.
Lordship,
Let us go step by step.
Lordship.
So far, you have told me that these two petitioners are appointed.
Yes, Lordship.
And the school, as well as the services of the teachers, including the petitioners, were incorporated in the list prepared.
Lordship.
District-wise list
List, Your Lordship.
of venture LPME schools.
Hmm.
So annexure 1 is that district-wise list.
List, Your Lordship.
Correct.
Yes, Lordship.
And the school appears at serial number 30. Is it not correct? Serial number 30. Then how many teachers have been shown there? Hazarika is there, then
Yes.
Biswas is also there.
Hajarika there, Your Lordship, Sankar Roy, Sapan Kumar Biswas, Pradeep Das, Your Lordship.
Petitioners are there.
5 teachers are there, Your Lordship.
Hmm.
Total.
Then thereafter what happened?
Yes, Lordship. The petitioners of item number 25, Your Lordship, challenge this provincialization, Your Lordship.
Petitioners of item 25.
No, 25, Your Lordship. 25, Your Lordship.
The next case, they
Yes,
challenge.
yes, the next item, Your Lordship.
What did they challenge?
They challenge.
Challenging the provincialization list that which was published because the Francis Hazarika and the petitioners in the item number 24, they are the junior to me and
No,
they are
no.
they are recommended, but my name is not recommended.
Okay.
And
It was some, I think, some mistake was there, Your Lordship. It was not against me. It was against the rest of the teachers, Your Lordship, whose name are reflected in the provincialized list.
No, which list is
Pranjit Hazarika and Sapan Kumar Biswas. It is not against me, Your Lordship.
which list is challenged? This page 20?
Yes, Your Lordship. 20.
20.
20.
website or published in the website on 6/3.
Yes, Your Lordship. Yes.
Now, this page 20, this is a recommendation list.
Recommendation list, Your Lordship. District-wise, Your Lordship. There is nothing allegation against me, Your Lordship. It was the rest of the teachers, Your Lordship. We file, yes.
Not me, you should say us. There are 2 of them, na?
2 of them, not against us, Your Lordship.
Oh.
And we file representations, Your Lordship. There is no reply.
So, okay, now please proceed. Now, this list was there. Then when was this list prepared?
It is 6 March 2013, Your Lordship.
6 March 2013.
Your Lordship.
Okay, thereafter what happened?
Thereafter, they have challenged the recommendation list, Your Lordship.
Which list? This list?
This list. Then, Your Lordship, the matter pending before this honorable court, Your Lordship. And after that, Your Lordship, if Your Lordship. It is, Lordship, 2 March 16, Your Lordship. There's a finding, Your Lordship, will got it, page number 63, Your Lordship.
63.
3, Your Lordship. So relevant portion, Your Lordship, will get it 66, Your Lordship.
No, no, not relevant portion. I want to know who has filed this writ petition. Bonita Bora.
Bonti Bora and Nirmali
Bora.
and Nirmali Hajorika, Your Lordship.
Their names are not there?
They are in the
list.
petition, Your Lordship.
Their names are not there in the list, is it?
Yes.
Bonti Bora, Hajorika,
Yes, madam. Their name is not there.
That is why they challenge.
That's why they might challenge this.
That is why they
That is
challenge.
there. Their name is not there in the list, Your Lordship.
Okay, now this was filed in which year? 2013.
13, Your Lordship.
Disposed of on
Immediately, Your Lordship.
2016.
16, Your Lordship.
Please come to page 64 and read the second paragraph onwards.
The petitioner claiming that they are serving as assistant teacher in Catholic Mission ME School, Salna in the district of Nagaon since the year of 1991 and 1992 respectively. They are aggrieved since the school authority did not forward their names for provincialization of services under the Assam Venture Educational Institution Provincialization of Service Act 2011. Whereas the respondent school authority forwarded the names of private respondent number 8 to 11 for provincialization under the SAPE 2011 Act in their place. At this stage, Learned Counsel for the respondent number 7 to 11 placed before the court that the school in question, namely Catholic Mission LP ME High School, Salna District, Nagaon, Assam, are managed by Diocese of Tezpur and is a minority educational institution within the meaning of Section 2Z of National Commission for Minority Educational Institution Act 2004 and a minority educational institution covered under Article 30 of the Constitution of India as per the communication under number F number 14, 16, 18, 25, 26, 28, 29, 31, 36, and 37 of 2001/41831 dated 8 March 10 of the National Commission of Minority Educational Institution, Government of India.
Just stop there for a moment.
Lordship.
Names of respondent numbers 8 to 11 were forwarded. But these two petitioners' names were not forwarded.
No, Lordship.
That was the grievance. So this 8 to 11 are some other names.
Some other names here, not me, Your Lordship.
It's not
us.
Pranjit Hazarika or Swapna Kumar Biswas.
Yes, Your
correct?
Lordship. Right, Lordship.
So which list are they talking about then?
That is 20, Your Lordship.
Page 20.
20, Your Lordship.
Now, coming back to page 20,
Lordship.
these respondent numbers 8 to 11, their names are there?
Yes, they are, Your Lordship.
What are the names? Ionas Lakra.
Ionas Lakra, Your Lordship.
Then
8.
Shankar Roy
Shankar Roy
is there. Then Pradeep Das is there. Then Benedict, Bedic.
10. Shankar Roy.
Benedicta Bhagawar.
Yes.
He's not there.
He's not there in the list.
No, my lord, may kindly see page 21, my lord. Annexure 1, that is serial number 123, my lord. This Catholic Mission School is a, my lord, 3 school, 1 LP, 1 ME, and 1 high school, my lord. So Benedicta was, my lord, in LP school.
But name is not there.
Yes, they are, Your Lordship.
Who is there?
123 column, Your Lordship.
Serial number 123.
Benedicta Bhagwan. Okay.
Benedicta Bhagwan.
All right.
So
the petitioners in that case have taken the names of others, not the two present petitioners. Okay.
1 LP school.
That much we've understood. Then
After that, Your Lordship will kindly come to again page number 66, Your Lordship.
what about 65? Not required.
The relevant portion is there, Your Lordship, for that, Your Lordship.
So
Otherwise, I can-
you know your case by heart. So you think everybody knows your case. You have to express. This is what has happened.
Yes, Lord.
How do you expect the court to write a judgment without the facts being?
Because, Your Lordship, what happened on 2 March 2016, Your Lordship, what have,
Okay, just read 66 after
yes,
hearing.
Your Lordship. After hearing the parties and perusing the documents furnished by Mr. Sagar, the school in question is found to be a minority educational institutions under Article 30 of the Constitution of India, and therefore the court is of the considered opinion that this writ petition is not maintainable and accordingly stands closed, Your Lordship. So that is the fact because of.
You could have said that in the first place itself, in
I'm-
two sentences. We had to discover it ourselves.
To say that, Your Lordship. So for that reason, Your Lordship, the petitioner and the respondent, Your Lordship, file review petition. Prefer review against this judgment, Your Lordship.
They filed review.
Review, Your Lordship.
Then what happened to the
Then what
review?
happened, Your Lordship?
He was allowed.
Review allowed, Your Lordship.
Okay, review was allowed.
Allowed, Your Lordship.
Let us,
Again,
that is why the matters again.
Again,
Yes,
Your
sir.
Lordship.
Where's the review order?
Yes, Your
Show me.
Lordship. Page number 135 to 140, Your Lordship.
135. 135.
It's affidavit, in my affidavit, Your Lordship. Additional affidavit, Your Lordship.
What was the specific reason for allowing the review?
Yes, Your Lordship. Lordship, kindly. Come to 140, Your Lordship, page number, Your Lordship. That is relevant portion is there, Your Lordship, I can. Paragraph number 22, Your Lordship. May I read, Your Lordship?
Yes.
Relying on a decision of Honorable Supreme Court, more particularly say Ambika Prasad Kedia and others versus State of Assam and others in civil appeal numbers 1710 to 1721 of 1987 and 1074 of 1987 cited in the case Arya Sama versus State of Meghalaya, a decision of the learned single judge of this court in WPC number 72, 1999, decided on 24/11/2000, a division bench of this honorable court in the case of Dipankar Bhattacharya versus State of Assam and others Supra relates to Bengali Higher Secondary School, Gauhati, a minority educational institution under the provision of Article 29 and 30 of the Constitution, have held that the state shall not, in granting aid to the educational institution, discriminating against any educational institution on the ground that it is under the management of a minority, whether based on religion or language, and that Article 30 must be read as a whole, and the fact that a minority educational institution accepts all does not imply that the community concerned has forfeited the rights to administer it. Considering the entire aspect of the matter, the law laid down by the Honorable Apex Court and the decision of the Honorable Division Bench of this court is of the view that the order dated 2 March 16 passed in WPC number 3/1913 needs to be reviewed. So that is the reason.
So what does it mean?
Your Lordship, the emphasis was reading the 29 and 30, Your Lordship, together, Your Lordship. Not to discriminate the education, Your Lordship, managed by the minority education, Your Lordship. Because our educational institution has been managed by diocese, Your Lordship.
Finding was the school in question is found to be minority educational institution
Yes.
under Article 30.
30.
Therefore, writ petition not maintainable. Give me constitution. Sorry? It's not yes. Oh, that's there. Okay. Sorry?
There is again, before this whether the minority educational institution established and administered under Article 30 of the Constitution can be controlled by the government of Assam while provincializing the services of teachers in such institution.
Right of minorities to establish an institution. Right to establish an institution. Okay, just. Things should ensure that the amount fixed by or determined is low. Underwrite country this term.
Section 29 Institution.
Okay, so according to the code, since the submission was made
Yes, Your Lordship.
that the schools under the minority thing
Mm.
cannot come under the 2011 Act.
Mm.
That is why it was found to be not maintainable. It was closed.
Yes, Lordship.
But on review,
Mm.
taking the decision of this Supreme Court and this division bench,
Yes.
Yes.
state shall not, in granting aid to education institution, discriminate against any indication of ground. It must be read as a whole, and the minority as all doesn't imply that they administer it. So now it says that the Supreme Court and the division bench judgment says that they can be considered.
Yes, Lordship. They can be considered, Your Lordship.
So that's why it was restored.
Lordship.
Okay. So we are back to square one. Now, what is your case?
Now, Your Lordship, the respondent number 4, Your Lordship, that is the Director of Elementary Education, file an affidavit in opposition,
Yes.
citing 2 grounds, Your Lordship. That is page number 116, Your Lordship.
2 grounds for
Your Lordship,
non-consideration.
Your Lordship, they said, Your Lordship, that my school, Your Lordship, comes under minority educational again, Your Lordship. Again, they have
Where is
taken
the affidavit?
it at page number 116, Your Lordship.
116.
116, Your Lordship. My,
Paragraph number?
it's Your Lordship.
Which paragraph?
Lordship. Yes, paragraph number
3.
3, Your Lordship.
Read it.
That the deponent begs to state that school in question does not come under the purview of the Assam Venture Educational Institution of Service Act 2011. As such, the state respondent cannot provincialize the service of the petitioner. It is pertinent to state herein by the deponent that the Assam Venture Educational Institution Act as amended in 2012 first, it was a ground of step down, Your Lordship. Again, Your Lordship, paragraph number 2, Your Lordship. Your Lordship, kindly consider paragraph number 2, 117, Your Lordship.
Yes.
The answering respondent begs to state that the Catholic Mission School, Nagaon, is a combined school of LP, ME, and High School of Nagaon district. And the same is managed by Diocese of Tezpur and is a minority educational institution with the meaning of Section 2Z of the National Commission for Minority Educational Institution Act 2004. And a minority educational institution covered under the Article 30 of the Constitution of India as per communication dated
of National Commission of Minority Educational Institution, Government of India. So this two aspect they have considered, Your Lordship, that is over already, Your Lordship. That is paragraph number 2. Yes, Your Lordship, the paragraph number 3 is still there, Your Lordship. The 2011 Act has been struck down, Your Lordship. Otherwise, Your Lordship, in my affidavit, I have relied on the Deepak Das case, Your Lordship. The case of coordinate bands of Deepak Das case, Your Lordship, as because my name has been enlisted, Your Lordship, my name has been recommended, as Your Lordship seen page number 20, Your Lordship. Already Director of Elementary Education, Your Lordship, recommended my name, Your Lordship.
Take me to your rejoinder affidavit. Which
Yes,
one?
Lordship.
What have you relied upon? Which case?
Yes, Your Lordship. That is Your Lordship will find it out at page number 142, Your Lordship.
Dilip Das.
Dilip Das, Your Lordship.
You are relying upon this.
Yes, Your Lordship.
What is the issue involved there?
Because, Your Lordship, it was the Act of 2011. At that time, Your Lordship, my name has been recommended, Your Lordship. Section 3, Your Lordship, of section 2011 Act, Your Lordship. I'm reading, Your Lordship. Basically, section 4, Your Lordship. I'm reading the 2011 section 4, Your Lordship. Employee to be government servant. The services of the employee of the all eligible venture educational institutions under section 3 shall be deemed to have been provincialized on the date of coming into force of this act, and they shall become employee of the state government with effect from that date, provided such institution have completed at least 7 years of imparting education from the date of affiliation, recognition, concurrence, or permission, as the case may be, on the date of coming into force of this act, Your Lordship. So
Section 4 of?
4 of 2011 Act, Your Lordship, Provincialization Act.
Page number?
Page number, Your Lordship, 653, Your Lordship.
653.
3, Your Lordship.
But the act is struck down.
Struck out, Your Lordship.
Then what will happen then?
It was, what is my submission? What is I was supposed to submit, Your Lordship, because of the 2011 Act. My service, Lordship, by operation of law, automatically provincialized because of this wordings of section 3 of the 11 Act, Your Lordship. So my submission is that, Your Lordship.
Section 3 or section 4?
Section 4, Your Lordship. Section 4. So that is the Dilip Das case is saying, Your Lordship. It was a word, Your Lordship. Now it is not there, 2017 Act, Your Lordship.
Your institution is affiliated to whom?
Your Lordship.
Your school is affiliated to whom? Affiliated to dash recognized by whom?
It was diocese, Your Lordship. It was in the case of Lordship.
You just read section 4.
Yes, Lordship.
Subsection 1 of the 2011 Act, which clearly says that provided such institutions have completed at least 7 years of imparting education from the date of affiliation.
Yes, Lordship.
Affiliation to whom?
It was managed by, otherwise my school is ME school, Your Lordship.
Your ME school is affiliated to which authority?
Otherwise it was yes, SEBA, Your Lordship. SEBA, and the recognition is there, Your Lordship. It was managed by diocese, Your Lordship, and permission is also there. I have annexed all these documents, Your Lordship. My writ petition, Your Lordship.
But the point is 2011 has been struck down.
Struck out, Your Lordship.
So can you go back in time now, saying that
So
at that time I was eligible to be considered at that time?
yes, otherwise it
So
was.
even now you should give me that benefit. Can you say that now?
No, Your Lordship, I'm not on that because I have obtained instruction from my petitioners also. They have no objection, Your Lordship, if my school has been provincialized under 2017 Act, Your Lordship, because they are struggling from 2013, Your Lordship. Because
Yes, other choice.
Your Lordship.
You have no other choice except to
Yes.
by 2017.
Yes, Lordship.
Can you insist upon going back to 2011 when the act itself is struck down?
Yes. Otherwise, Dilip Das case was there, Your Lordship. There is no administrative order.
So
is
there's
needed.
no
It was-
point in saying I have no objection. You cannot have any objection at all.
Lordship.
Not the provincialization list, the provincialization list is not in the finality stage of finality. So as per 2017 Act, it is adjudicated by the education tribunal. As per section 29 of this Act.
Okay. We'll come to that. Let us complete our part. Now you have taken me to page 142.
Yes, Your Lordship.
What does this judgment say?
Lordship. May I read the main, Your Lordship? That is, I'm relying on 6, 8, 11 and 13, Your Lordship, paragraph number. Paragraph number 3 also, may I read, Your Lordship?
See, problem with you is that
Otherwise, Your Lordship. Otherwise, Your Lordship.
problem with you
Yes,
is
sir.
that you are reading here, little bit from here, little bit from there, without bothering to explain what it is about.
No,
This is
otherwise
not-
the Dilip Das case is saying, Your Lordship, by operation of law, Your Lordship, the service of Lordship teachers have been provincialized by operation of law, Your Lordship. Section after relying section 4 and section 10 of the 2011 Act, Your Lordship. For that, Your Lordship, I am relying this judgment, Your Lordship, and paragraph number 6 at 11, 13, Your Lordship, speaks specifically regarding that, Your Lordship. It is, as already, may I read the paragraph number 6, Your Lordship?
So I think you basically rely upon paragraph 12, 11, 13 of the judgment of this, what do you call it?
Dilip Das case, Your Lordship.
Dilip Das case. But one thing is there,
Lordship.
merely by showing me that page 20 where your name is there.
Lordship.
Can it be said that you have the vested right to be considered because of your inclusion of your name? Because that was only a proposal.
Proposal, recommendation, Your Lordship.
Recommendation which has not attained finality.
Yes, yes, Your Lordship. Finally.
That is why,
Hmm.
on the basis of that page 20, can you say that I should also be carried forward? That is the question to be looked into.
Yes, Lordship. Otherwise, I was supposed to submit on that point because, Your Lordship, it was in the year of 2013, my name has been recommended, Your Lordship. Under section 3, Your Lordship,
what is my submission? Otherwise, your lordship, if your lordship, because the petitioners are struggling since 2013, your lordship. Otherwise, if your lordship kindly, they have no objection, your lordship, if their school has been provincialized under 2017, your lordship. My submission is on that point also, because it was struck down, Dilip Das case is on that point, your lordship, because there also the school did not get the finality, your lordship. Did not attain the finality, your lordship, in Dilip Das case also, your lordship. For that reason, your lordship, I am relying the Dilip Das case, and other cases are also there, your lordship. But your lordship, as struck down case, I don't want to stuck this case for a long time, your lordship. For that reason, I talked to my client, your lordship, and they consented, your lordship, that they have no objection, your lordship, if school has been provincialized under 2017 Act, your lordship. That is my one more submission, your
If
lordship.
school has been. Is it already provincialized?
No, lordship.
Then
It was recommended, your lordship.
why do you say has been then?
Oh, lordship.
They have no objection if the school and the teachers are provincialized under 2017 Act. Is that what you mean?
Lordship.
Is that what you mean?
Yes.
I think we have some.
They have.
Hmm.
If their school will be, your lordship, provincialize, your lordship, under 2017 Act, your lordship, they have no objection, your lordship. That is, I mean to say, your lordship.
Okay.
Yes, lordship.
So don't use has been.
Lordship,
If you
lordship.
say has
lordship,
been, then it's
lordship,
already
lordship.
provincialized.
Yes, lordship. Apologies,
Hmm.
lordship. One
So under 2017, what is the procedure then?
the same thing, your lordship, needed, your lordship. Otherwise, my learned colleague says it was 29, your lordship. According to section 29, there's a tribunal, your lordship. But it was a long pending case, your lordship, since 2013. It's going on. Again, if your lordship kindly send it to tribunal, your lordship, it will take another
Section
29, your lordship.
29 of this 2017 Act.
17 Act, your lordship.
In many cases, we have sent them to the tribunal. Section 29.
9. Lordship.
No. Of which Act? Just a minute. 29.
No, I couldn't.
29 of which Act?
29, no.
Hmm?
No, it was not there, your lordship.
I had selected.
Oh.
What is the provision?
No. I come to 29, 9. No, so 19.
19, sorry.
19, your lordship, it was. Not 29, your lordship.
Are we holding the same book?
Same book, your lordship,
Page?
125, your lordship. 125, lordship, will find out. 124, your lordship.
Section 19.
19, your lordship. No suit, prosecution, or other legal proceeding.
Read.
Your lordship. No suit, prosecution, or other legal proceedings shall lie for anything in good faith done under this act except with the previous sanction of the state government. To adjudicate disputes for redressal of grievances relating to the teaching staff of the non-governmental educational institution, as well as disputes concerning disciplinary action, genuineness of establishment of school, and claim for provincialization in respect of teaching staff of Vansar educational institution, there shall be an education tribunal for its district within their respective territorial jurisdiction, the district and session judges and the additional district and session judges of its district are designated as educational tribunal. Your Lordship.
So it's clear.
There, Your Lordship. One tribunal is there, Your Lordship.
District judge is the.
Yes, district judge will be the presiding officer, Your Lordship, of the
So?
tribunal.
Why should it not be referred to that tribunal then?
Because some matters are disposed of by this honorable court, Your Lordship.
Yeah,
Even
show me that. What are those matters?
no, some matters are there, Lordship, provincialization matter, which are not even before the education tribunal, Your Lordship. Similarly situated person.
So show me those decisions where some matters have been disposed of despite the section 19.
No, not section 19, Your Lordship. By this honorable court, Your Lordship.
There's some understanding problem. We have some communication problem.
Hello, if your Lordship allows me, my lord, I'll just point out. There is a provision that this was a proposal, your Lordship rightly said. This was in this proposal, there is a compass. In Nagaur district, there is a campus called Mission Compound.
Mission compounds.
There are 3 schools. One is LP school, one is ME school, and one is high school. So LP school has been provincialized in the year 2013. And high school has been provincialized in the year 2021. And provincialization of this LP school, the ME school, has not been taken into consideration because of the pendency of this case. Rightly or wrongly, my lord, that act has gone. Now it was in the proposal stage. So it has to be started afresh. This afresh thing has to be started under section 13 of the Assam, it is page 120. So the matter has to be sent back to the scrutiny committee to start afresh and complete the process. Provincialization of the school means provincialization of the services of a teacher.
Middle school.
Middle school has not been provincialized.
LP school already provincialized. And high school provincialized.
Provincialized.
LP school was in 2013.
13.
Under the 2011 Act.
Proposal was there.
And the high school provincialized under the 2017 Act. Now the middle school remains because of the dispute here.
The matter has to be sent to the district, let it go to the district elementary education officer, who will send the matter to the district scrutiny committee and state level scrutiny committee. Section 13.
Provision is section 13.
So your lordship will send back the matter to the this committee, to the director of elementary education, to send back the matter to the district scrutiny committee and state.
Mr. Das, you are in which case?
I am in next case.
The next
Same
case.
matter. Same
Okay.
matter.
Okay.
Your lordship
So
gets
at some point of time, some names were there,
names there.
but that has to be done afresh.
It has to be done.
So
afresh.
everybody has to be taken into account.
Yeah,
Everybody's case will be taken into account.
This is that they are senior to us. So therefore, their cases to be considered. Let the body consider it.
Correct. Because the Act of 2011 is there, not there anymore. It's gone.
Gone.
So what had happened under 2011?
It's a proposal only. So there, your lordship may say that their names were there in the form of a proposal. It has not been finalized. So 2017 Act has come into operation. So therefore, under the provisions of the 2017 Act, fresh proposal may be started. It has to be done.
Correct. Understood, Mr. Das. I've understood it. But only one thing which this lady advocates, she says that she is covered by this Dilip Das case. Dilip Das case says that whatever benefit we have already received.
Proposal, my lord. No benefit has been given to anyone.
So that's what they say. I mean, that's a submission. That's a submission. Accepting that or not is a different thing. But this is what this is the stand taken by here.
It's correct.
That our name is already there earlier, so it should be taken forward.
It's a proposal only. They could have just rejected it on that day itself. It has to be finalized.
So if the party agrees, there's no difficulty in giving that direction.
Yes. So this is what otherwise.
As per the 2017.
It's been coming day after day after day and all. It has, and because of the pendency of this case, some teachers, if they are agreed by anything, they can come. If I am agreed, I will have to come. I am representing the three petitioner, 3 respondents here. Respondent number 8, 9, 10, and 11.
So all of you agree to that?
Agree, but
I am giving 21 and 21 years service in that school, and now I am.
No, that will
be
be taken,
considered-
that will be considered and taken into account by the authority. We are not saying anything
They
that,
are not continuing the school, your lordship.
So now,
So that's a different case now.
I was not allowed to continue my service after giving 21 years of my
okay,
services.
in the next, in which case?
In
Next case, your lordship.
But in the next case, I think Mr. Das is there.
No, they respond in your lordship.
Oh, you're the
Petitioner,
respondents,
yes,
you're the
lordship.
petitioner. So what is your prayer then?
My prayer is just sentence that before the judicial tribunal to litigate this matter.
But tribunal will come later on. First, it has to go to the scrutiny court.
Now, tribunal is one thing, and another thing is that you're no longer working. You're not working since when?
Since third and 2013, after publishing this,
List, your lordship.
list, I was not allowed to continue. my
2013,
list.
13. So 12, how many years now? 13 years. Then how will your name be considered now at this stage?
Because fresh that it should be started at fresh. I'm not continuing and then the teacher in the school.
So first of all, there has to be a finding that you could not have been discontinued. Hence, even if you are discontinued, you are eligible to be considered as per the 2017 Act. So that finding has to be made by this court. Without that, you don't figure in the picture. We'll hear you. Let her complete her thing. Are you agreeable with that? That you go back?
No, no.
In 2017, let there be a fresh consideration as per section 13.
Lordship. But one problem is there, your lordship, with 2017, your lordship, because section 4, your lordship, from coming into effect of the notification, I will get the benefit, your lordship. Because notification is still yet to come, your lordship. So that is there, your lordship. So that may be considered, your lordship, at least
Consider that
because,
you
your
cannot put
lordship,
the cart before the horse. First, you get some relief.
lordship.
Once you get the relief, you say that this relief should be from this anterior date. Then court may consider. But at this stage, we cannot sort out everything and say that you consider like this only. Not like that, but like this only. That cannot be the direction. So there has to be a limit.
There, your lordship.
There has to be a limit of how you like seek relief.
Because some teachers are going to be retired, your lordship, even very recently, your lordship.
That's why instead of sending it back to the file rack to be listed after 2-3 years, let us do something now, and whoever remains can be considered. So there is a sum and substance in your case. Let me hear the other side, the second writ petitioner. See, you are out since 2013. Now, what relief can you get at this stage?
My simple prayer was that initially when the list was published, lordship, then my name was not in the list, lordship. In annexure 4, page number 28. And so therefore we have challenged the list as we have joined in 1991 in the school. And with 21 years of continuous services, my name was not in the list. So therefore
your name is not on the list.
Not on the list.
And since then you are out from service.
Lordship.
After the list was prepared.
You
are not allowed to join.
I'm not allowed to continue my services. Therefore, I am challenging this list, and as after that, I'm submitting my representations to the Director of Elementary Educations, lordship. Then I have filed an RTI in annexure 6, lordship. Why my name is DICE format in the year 2009-10, an approval order of the teaching and non-teaching staff and Catholic missions, and provincialization form. And therefore, in 2013, I have submitting a representation before the Deputy Commissioner, Nogga also. Lordship.
Where
But
is
my
that?
representation was not considered, Lordship.
Where is your representation?
My representation is, Lordship, page number 35 of the writ petition, at Annexure 8, Lordship.
That list was prepared and when was it prepared?
List was prepared, list was published on list was prepared on I think 6
February,
March 2013.
6 March.
March, Lordship.
And your representation is 7 March. No, 7 May.
7 May, Lordship.
But what are you doing now? This was way back in 2013.
Lordship.
Is the issue alive? You must be employed elsewhere also by now. Your clients, do they want to pursue this matter or not?
So they have not attained the age of 60, so they are continuing to pursue the
60.
Lordship. Yes.
What is the age?
I think, Lordship, as per this affidavit, Lordship,
This writ petition was filed in 2013.
13, Lordship. At that time,
46.
Lordship, 46. Lordship. Now 13 years, Lordship, almost 59 of Lordship. Fifty-eight, 59.
Is there any bar that consideration of provincialization has to be done before attaining this much years?
No.
Or you can be considered till the last date? Tomorrow you are retiring, today also you can be considered.
Yes, Lord.
There's no bar.
No bar. So now, Lordship, I am not continuing as my sir, so my name is automatically not considered, as I am not continuing my services in this school.
Definitely.
Definitely, Lordship.
So why should we direct your consideration? You are out of service for a long time now.
Lordship.
What will you teach? You must have forgotten everything also. Huh? Your writ petition was dismissed
Lordship, my petition was dismissed
in the year 2016
2016. Lordship.
and revived in 2025.
25, Lordship.
When did you file your review?
Review was filed in the 2022, Lordship.
Review is 2021. Review petition number 72 of 2021.
72, that was not filed by us by Lordship. I was my review petition is 85.
Okay, yours also was dismissed
Lordship.
on similar ground.
Lordship.
I see.
My review petition 85. That
Where
was
is that
filed-
page number? It's not available here.
Lordship, maybe. Review
And
petition may not be.
your writ petition was dismissed on which date?
The writ petition was dismissed on
2
Lordship.
3/16.
16 Lordship.
Okay, yes, I got it.
Lordship. In my review petition, that is.
Review petition number
अच्छा अच्छा ठीक है
72 of 2022.
72. Yours is 85.
There is two review petitions.
85
Yes,
of 2020.
85 is mine. Lordship.
But how come one is a common order, one is again separate order?
The common order. Lordship.
Oh, it was by a common order.
Common
Okay,
order.
okay.
Lordship.
Date of order is 26/25. Okay.
Oh. ठीक है मैं कोई
So thing is whether a direction can be given at this stage to consider your case also.
Lordship, actually, Lordship, I have perused the record and it is revealed that I was not allowed to continue my job not 2000 from not 2013. It is from 2018, Lordship.
From where is that? From where are you saying that?
So, Lordship, in my review petition, we have stated, Lordship, in
No, not in review petition. In your writ petition, what have you stated? You have taken two different stands.
Lordship.
Different stand in
In
writ
18.
petition, different stand in review.
No, Lordship.
Have you mentioned anything in the writ petition
Lordship.
that I am not in the list, and since my name was not on the list, I have not been allowed to continue? Anything like that?
Lordship.
Okay, you find out and point it out. Let me hear Mr. Das. Anything else to be submitted, Mr.
My case is that they are senior to us, so they should have been included in the provincialization proposal. Our case is that they were appointed in a high school and we are working in a ME school. So our case should be,
You are ME school.
I'm.
They are high school.
They are high school. He is high school.
High school.
Lordship.
That's what we said, but irrespective of what I submit. And let the case of the petitioners, the respondent be taken into consideration by the district scrutiny committee. And your lordship will refer the matter to the director elementary education, who will take appropriate action for sending the matter to the scrutiny committee for finding out the eligibility of the persons who are liable to be provincialized.
But
As
I
per provision
also
of
ME
15
school, Lordship,
So before that, we have to be clear. You are studying, you are teaching in ME school or high school?
ME school, Lordship.
ME school.
Annexure 1, Lordship. Annexure 1, we have stated our experience certificate that this is to certify that the Bonti Bora, resident of so and so, was teaching in our Catholic mission ME school, Salna, Nagaon from August 2019 to till December.
Mr. Das, you had submitted that LP school already provincialized.
Yes.
High school already provincialized. What domain is the ME school?
ME school.
Yes.
So that means all of you are from the ME school
school.
only. If he's from the high school, then
That is,
It's
I mean-
not, well, I'm not saying, but in our affidavit we have stated, no, I'm not going on this, but the lordship will consider. it.
They'll verify.
Yes, let them verify and.
Let's
There is
dispose it.
norms for,
Okay, we'll dispose it off.
well,
Let it go back and let them decide what to do.
Lordship.
There's no point keeping it here.
in a stipulated time.
By 2-3 months, you'll become overage. Then nothing will happen.
Yes.
Lordship.
Okay, hard. Miss G. Bora. Miss G. Bora, learned counsel for the petitioner. For the petitioners in WPC number 98 of 2022. Any private respondents? In your case, any private respondents?
I am for the respondent number 89. For the matter of the management.
In which case?
In 24, item number 20.
Just a minute. Elementary, who was there? Elementary? Comma, Miss S. Goar, learned standing counsel, elementary education. For the said department. Mr.
SRN.
No.
G.
Sorry?
G.
Giuddin. Learned counsel. For the
Respondent number 8 and 9. 9 is the included respondent.
respondent number 8 and 9. And Miss K. Fugan. Government advocate for respondent number 1 and 5. Stop. Also heard Mr.
SRA Nasir.
S.I.
SRA Nasir.
S.R.A.
No, yes, Lordship.
Where is your name?
Item
S.R.A.
number 25, Lordship.
S.R.A. Nasir.
Nasir, Lordship.
Learned counsel for the petitioners in WPC number 3393 of 2013. Then Miss S. Kaur, learned standing counsel, elementary education for the respondent numbers 1, 2, 3, 5, and 6. And Miss K. Fukan, learned government advocate for respondent numbers, for respondent number 4. 1 and 4. Okay, 1 and 4. No, in the second case. Respondent number 1 and 4.
And for 8, 9, 10, 11.
And Mr.
Eight,
Before
nine,
that,
10,
no,
11.
before that,
Yes.
7.
Mr.
G.
Giuddin, learned counsel for respondent number 7. And Mr. B.D. Das, learned senior counsel, assisted by Miss
R.
R. Deka for the private respondent numbers 8, 9, 10, and 11. So both the writ petitions are taken up for disposal through this common order. Since the issues involved are similar and identical. Next para. Facts of the case in brief is that there is a Catholic mission school at Salna in the district of Nagaon, Assam. Which comprises of law primary section, comma, what is ME stands for? ME,
Middle
Middle school.
middle elementary.
Middle elementary school.
comma, middle elementary section and high school section. Stop. The undisputed fact is that the lower primary school, lower primary section has already been provincialized in the year 2013. Under the, what is that full form of that act? 11 Act?
Provincialization.
Under the full name?
Assam Venture Educational Institution.
Assam Venture Educational Institution,
In bracket manner provincial.
open bracket, Provincialization of Services, close bracket, Act 2011.
Amended in 2012. This is also amendment.
As amended in 2012. Stop further. Insofar as the high school section is concerned, the same has also been provincialized
2017.
as per the, has been provincialized in the year 2021 as per the Assam Education, open bracket, Provincialization of Services of Teachers and Reorganization of Educational Institutions, close bracket, Act, 2070, open bracket, Act of 2070. So therefore, what remains is in respect of, what remains is the provincialization of the middle school section. Middle elementary. English.
Upper primary. Middle English means upper primary school or.
Middle English. Bracket, upper primary section. Before also you put that, huh? Instead of middle elementary, you write middle English. Bracket, upper primary school. Next para. It is the projected case of the parties concerned that a district-wise list of venture LP/ME school was published in the official website of the respondent authorities concerned on 6/3/2013, wherein the name of the petitioners in WPC number 98 of 2022 figured at serial number 30 and serial numbers 30 and 123 respectively for the district of Nagaon. So while the process for provincialization of their services was being considered, according to the said petitioners, the petitioners in WPC number 3393 of 2013 Is it 13? Had approached this court and pending finalization of the said writ petition, the case for provincialization of their services could not be taken up, could not be taken forward. Stop. According to the petitioners in WPC number 98 of 2022, they were not even arrayed as the private respondents in WPC number 3393 of 2013. And therefore, inclusion of their names in the district-wise list of venture LPME schools published on 6/3/2013 did not affect cancel that, should be carried forward independent of what the petitioners in WPC number 3393 of 2013 had initiated in the writ petition. Stop. However, it so happened that these two writ petitions were rejected on the same order or separate order. Where is that? Both the writ petitions came to be considered together, but where is the link case?
There is only one thing at that time. Now review petition has been filed, review petition has been filed by petitioner and respondent authority first. There, your lordship, at that.
No, see, that is not the question. Maintainability of this writ petition.
63, 66.
In that writ petition, we have filed a writ petition and our writ petition is only rejected. Our writ petition is rejected.
Rejected.
By judgment dated 2/3/2016.
So in
The
my
writ-
petition, it is
The
24th
petitions
of
were rejected,
Okay.
dismissed on the ground that the Provincialization Act will not be applicable for this.
As this is a minority institution.
Minority.
3393 was rejected.
Rejected. On the
Then
ground that-
98 was not rejected.
No,
No.
There's a fresh case, your lordship.
Fresh case.
Fresh,
3393 was.
Sorry?
3393.
only 3393.
My writ petition was
The
rejected.
pendency of the review date.
No, but the review has been passed in two
Because, your lordship.
review petitions.
Yes,
Two
lordship.
review petition. One review 72 to file.
One is against 3393 order. And the other one?
3393 order is 2/3/2016. That was rejected by this honorable court. And when respondent has filed a review petition which was numbered as 72 review petition, thereafter we have filed a review petition which was numbered as 85 of this 85 of 2022 review petition number, and
Two review petition. One is for reviving WPC.
Same prayer.
Prayer, your lordship.
One is filed One is filed by the respondent authority. Respondent in the writ petition that is numbered as 72 review petition.
Okay, just a minute. So the petitioner as well as the private respondents
Lordship.
filed one review each.
Yes, Lordship.
Okay. What did I say? It so happened. Okay, we cancel that. However, it so happened that WPC number 3393 of 2013 came to be dismissed on the ground that the school in question was found to be a minority educational institution under Article 30 of the Constitution of India, and therefore writ petition was not maintainable. Subsequently, the petitioners in WPC number 3393 of 2013 filed review petition number
Review petition number 85.
before that, who has filed 72?
72.
2021.
Who filed it? 72.
The respondent number 7, respondent number 7 of the writ petition has filed a
Okay,
7 to 11.
then you write. Subsequently, the rest we cut. Subsequently, respondent number 7 in the writ petition, that is WPC number 3393 of 2013, filed review petition number 72 of 2021. And likewise, the writ petitioners also filed review petition number 85 of 2022, praying for recalling the order dated 2/3/2016, by which the writ petition was dismissed as not maintainable. By relying upon the judgment of the Apex Court in Ambika Prasad Kedia and others versus State of Assam and others. Bracket civil appeal number 1710 of 1710-1721 of 1987 and 1074 of 1987. Amongst others. Stop. Accordingly, the writ petition was restored to file vide order dated 26/2025. Next para. The learned counsel for the petitioners in WPC number 3393 of 2013 submits that the grievances of the petitioners was that despite their seniority position in the school, their names did not find place in the district-wise list of venture LP/ME school published in the official website of respondent of website on 6/3/2013. And therefore, they had submitted a representation before the district deputy commissioner.
District commissioner,
District
before the
commissioner,
director elementary education. Thereafter, Lordship, district elementary education officer.
Before the director elementary education officer on 19/4/2013.
13.
And thereafter, before the
Director, District Elementary Education Officer on 22/4/2013.
District Elementary Education Officer on 22/4/2013.
And also Deputy Commissioner, Learned Deputy
So
Commissioner,
the
Nagaon.
petitioners also filed their representation. Where is it, Deputy Commissioner?
Deputy Commissioner, page number 35, Annexure 8. On 7/5/2013.
Petitioners also filed their representation before the Deputy Commissioner, Nagaon, on 7/5/2013. Seeking the inclusion of their names in the list. Stop, since their representations was not considered, and therefore the petitioners, having no option, had initiated the writ petition. Stop, the Learned Counsel also submits that the petitioners continued to work in the school
Till 2018, Lordship.
any month,
Month I have to ask that
till the year 2018,
18, Lordship.
but thereafter they were not permitted to continue. Stop. The Learned Counsel, however, submits that as the petitioners have rendered long years of service in the school and with the revival of their writ petition, the petitioners who have not yet attained the age of superannuation are eligible to be considered for provincialization of their services in terms of the Act of 2017. Stop. The Learned Counsel submits that since the list was prepared during the subsistence of the Act of 2011,
11, Lordship.
the respondent authorities may be directed to consider their case as per the Act of 2017. Next para, the Learned Counsel for the petitioners in WPC number 98 of 2022 submits that although the case of the petitioners is squarely covered by the decision rendered by a coordinate bench of this court in Dilip Das versus State of Assam and others, reported in 2019, 2 GLT 135. The petitioners will have no objection if their case is considered in terms of the relevant provisions of the Act of 2017. Top, the Learned Counsel submits that the names of the petitioners indeed figured in the list that was prepared, and in view of the pending litigation initiated by the other teachers the petitioners have been denied the benefit of provincialization of their services till date. Next para, Mr. B.D. Das, Learned Senior Counsel, also submits that since the Act of 2011 has been struck down by this court and Act of 2017 enacted thereafter, court may direct the director of what? Director of Elementary Education to place the case of the teachers concerned for considering their provincialization before the
ME school, bola. Teachers concerned ME school. Teachers concerned of the ME school of.
teachers of the ME school. It's what, upper primary or low primary? ME? Upper primary, bracket upper primary school. Is it rule section 13?
13.
Before the district scrutiny committee and state level committee in terms of section 13 of the Act of 2017. Stop. He submits that the criteria for considering provincialization of service is already provided under the Act of 2017. And therefore, there will be no difficulty for the respondent authorities to consider the cases of all those who are eligible under the said Act for provincialization of their services. Stop. Next para, upon considering the submissions made by the learned counsels for the rival parties and upon perusal of the materials available on record, both the writ petitions are disposed of by directing the Director of Elementary Education, bracket, not bracket, Director of Elementary Education, Government of Assam, to place the name of the petitioners as well as the private respondents for provincialization of their services as ME school teacher in terms of the Act of 2017 by placing the matter before the District Scrutiny Committee in terms of Section 13 of the Act of 2017. Ms. Kowar, anything else to be done? Straight away, please. Stop it. To enable the Director of Elementary Education to do the needful, the petitioners as well as the private respondents shall submit their respective individual applications along with all such supporting documents that may be necessary before the Director of Elementary Education within a period of 15 days from today
Yes. From today.
of the Director of Elementary Education upon receipt of the applications shall do the needful as directed in here above within a period of 1 month. No, director will give it to the district scrutiny committee.
3 months is too long.
The petitioner will be retired. Your
Retired
Lordship.
always 15 days of superannuations.
When are you retiring?
One is in June, your lordship,
June of
June of 2027, your lordship.
27.
One.
this time.
One is, your lordship, it's very recently, your lordship. I forgot, your lordship, within 3 or 4 months, your lordship. I forgot, your lordship. That's lordship. That's forwarding it to your lordship.
Forwarding only.
Forwarding.
Forwarding.
Director will forward to the district scrutiny committee within a period of 1 month.
Scrutiny committee will finalize within a period of 2 months.
Yes.
The district scrutiny committee, upon receipt of the names and particulars from the Director of Elementary Education, shall consider and finalize the process. Then again, it has to go to the state level also, isn't it?
District level,
District level.
first district committee.
District committee.
Correct. So
District.
what did I say last night? Shall consider and finalize the process.
13.6, my lord, 13.6 is there. District will first scrutinize. Shall thereafter proceed to scrutinize and verify the service records of
That's
full service.
One state level.
Official identity. Based on
Uh, 10. 10.
Section 13,
Least
10, your
10.
lordship. State level committee is also there, your lordship.
To the concerned director. who shall be implemented. 6 and 7.
No, 10.
Last line, please agree again.
As per provision of this act.
We go to the director will forward the same to the state level collector. Seven is the. Director. State level committee.
Then state level committee.
Yeah, district level.
District level committee. Scrutiny.
Of scrutinization within a period of 2 months.
তাহলে এজ বিলাকো নিলিখা নহয় ইয়াতে
By referring the matter before the state level scrutiny committee. The,
Lordship, as per subsection 7, your lordship, the district scrutiny committee will forward the list
No,
to
I
the
think-
director, your lordship.
no, we'll do one thing. We'll just, the process is already here.
Process
Instead of,
yes, yes,
instead of
yes, your-
fixing time here and there,
Yes, yes.
just read from the thing part, disposed of by. Hmm.
State level committee and state level committee will complete the process as per provision of law.
Oh, supporting documents before the rest you cut. Also, the supporting documents, the rest you cut. To the Director of Elementary Education within a period of 15 days from today. Stop. Upon receipt of the same, the Director of Elementary Education shall take the matter forward in terms of section 13 of the Act of 2017 expeditiously. Stop the entire process of scrutinization by the District Scrutiny Committee and the State Level Committee be done and completed within a period of 2 months from the date of receipt of the communication from the Director. With the above observation direction, the petition stands disposed of.
Deeply obliged, person.
I'll just refine it again. So roughly it's like that. Some time frame will be there. Okay.
Around 2013 after 13.
Dispose of.
Yes.
Deeply obliged, person.
There is one IA also.
Yes.
Pending, dispose.
Your name has been, petitioner has been restrained from, that become
Pending.
infructuous, your lordship now.
Then IA also you say dispose, okay?
Ah,
In view of the order passing the writ petitions, IA is also disposed.
Time being 10.
May it please your lordship.
Yes.
The lordship matter pertains to examination of MBBS student. Examination of MBBS student, lordship. Here the petitioner is a student of Gauhati Medical College, lordship. Lordship may come to the impugned order, lordship, at page 26. Page 26 is the impugned order, whereby the respondent has debarred the petitioner from appearing in the examination, lordship. Lordship, here in this impugned notification, lordship, there are 3 students, lordship. Out of 3 students, lordship, in respect of 2 students, lordship, already this coordinate bench of this honorable court has disposed of lordship writ petition, wherein the writ petition has been allowed and this particular notification has been set aside and quashed, my lord.
For those 2 petitioners.
For those 2 petitioners, my lord.
Which one is your name?
Lordship, I am at serial number 2, Manav Jyoti Gogoi.
Okay.
I am at serial number 2, Manav Jyoti Gogoi. Lordship, the reason cited in this notification, lordship, for debarring the student from appearing in the examination, lordship, is the NMC regulation. My lord, as on date, lordship, the law governing this field regarding examination and admission of MBBS student, lordship, will find at page 36, my lord. A regulation at page 36. This is Regulation 1 Graduate Medical Education Amendment 2019, my lord. Lordship, this regulation puts one condition, lordship, that your lordship will find at page 41, my lord,
11.2.6, page 14 would be the relevant one. Page 41, my lord. Here it stipulates a learner shall not be entitled to
Wait.
graduate after 10 years
Just a
of,
minute. Let me also turn the page.
my lord,
Don't be in a hurry. Page number 40,
page number 41, my lord.
41.
Lordship, 11.2.6. The first line.
11. Okay, yes, read.
A learner shall not be entitled to graduate after 10 years of his or her joining of first part of the MBBS course. Lordship, this condition is applicable for the student who gets admission after 2019. And that is specified in page number 36.
36.
Page 36,
Where?
the regulation.
Where?
Page 36. Point number 2, subclause 1. I am reading. The regulation of graduate medical education 1997 from clause 2 to 14 contained in chapter 1 to 5 and the appendixes and schedules appended therein shall be included as part 1 of the regulation. These provisions shall be governing regulation with respect to the batches admitted in MBBS course until admission until academic year 2018-19. Lordship, my admission is in the year 2014. Lordship, subclause 2 of part 2 I am reading. Part 2 containing the following chapters shall be added to the regulations on graduate medical education 1997 that shall be governing regulation with respect to the batches admitted in MBBS course from academic year 2019-20 onwards. So Lordship, the condition which puts 10-year upper limit for completing the MBBS course is applicable for the students who gets admission from 2019-20 onwards. And admittedly, the present petitioner, he got his admission on 3/7/2014. That is why, Lordship, the upper limit of 10 years is not applicable for the present petitioner.
So,
Lordship,
there is
while
one
issuing
thing.
the notice,
No, that is one thing.
my lord, my lord,
And this particular impugn order,
my lord,
impugn communication annexure for page 26.
page 26, my lord.
Why it's issued like this? Because you have completed more than 10 years. That's why.
A Lordship, in fact, in my case, I have not even completed 10 years.
No, what is the reason behind that they cannot appear for further examination? Why is it so?
Lordship, they have stated that because of NMC regulation, which I have just shown before.
Because you have done more than 10 years after your admission. This is the reason.
My lord, the date when the notice was issued, on that particular day, even 10 year was not completed, Lordship.
No, that is a different thing.
That is a different thing, my lord.
I'm just asking you why it was issued. According to them,
within
you have completed 10 years. That's why you cannot.
According to them, I have completed 10 years, but I have not able to succeed in the
And
MBBS.
according to you, you are not covered by that case.
According
You're
to
not
me,
covered by that amendment. Amendment is only applicable from 2019-20 onwards.
Lordship.
And you say that other two writ petitions
Lordship.
were filed, they were disposed. How it was disposed?
Yes, Lordship. One more. Give this.
So you agree with that,
Yes.
Mr. Counsel? This is your instruction.
Lordship, this is from the National Medical Commission, my lord.
So there is no problem.
With regard to my lord, because the impugned order says that he is debarred from writing the exam for NMC regulation. If the NMC regulation in question pertains to the 2018-19 amendment of the GME rules, my lord, which states that a student cannot take more than 10 years, then my lord, unfortunately, my lord, the petitioner is not covered by that. Because the instruction also clearly speaks, my lord, that is WPC number 280924, that is the petitioner's case, my lord. He belongs to the academic batch of 2014. That is correct, my lord. Final line. In the above mentioned 4 matters, including the instant matter, the petitioners belong to prior to 2018-19 session. Therefore, there is no cap of 10 years on these petitioners in order to complete their MBBS course. So, if that is the only isolated criteria, my lord, for that reason, my lord, yes, they are not covered by the 10-year, my lord, limitation, which would be applicable to batches 2018-19 onwards, my lord. Apart from there, if there is any other, my lord, thing withholding their education, my lord, that my learned friend would be able to apprise me.
Lordship, considering the similar submission, Lordship, the earlier writ petitions are allowed and this particular impugned order has been set aside and quashed, my lord.
What was the reasoning given?
My lord,
What was the reason for setting aside?
Lordship. Lordship, I am reading.
Wait, don't read. I'm reading it myself. Same thing. And this one also. Two, 4, 4, 7. So we are passing an order. Third, Mr.
R. Karim.
Sorry?
R. Karim.
R. Karim, learned counsel for the petitioner. Mr.
DK Boido, my lord.
DK
For
Boido.
Respondent number 6, the National Medical Commission, my lord.
Learned standing counsel.
National Medical Commission, my lord.
National Medical Commission for respondent number
6, my lord.
6 and Mr. D. Upamanya, learned standing counsel, Health Department for
Respondent number 1 to 5.
respondent numbers 1 to 5. So the petitioner, by filing this writ petition, has challenged the communication dated 22/2024 bracket annexure 4, by which he, along with 2 other persons, have been debarred to appear in any MBBS examination as per the NMC regulation. Stop. The said communication has been issued by the Controller of Examinations, Srimanta Shankardeva University of Health Sciences, to the Principal of Jorhat Medical College, Jorhat. Stop. The petitioner apparently is a medical student of Jorhat Medical College, and by taking his date of admission as 3/7/2014 and also the relevant provisions of the regulation on graduate medical education bracket amendment close bracket 2019, the petitioner apparently is found to have completed 10 years from the date of joining the MBBS course, and therefore he has been debarred in terms of regulation 11.2.6 of the amendment regulation of 2019. Stop. The learned counsel, next para, the learned counsel for the petitioner submits that the petitioner took admission in the medical college for the MBBS course on 3/7/2014. Another relevant time, the amendment of 2019, the amendment regulation of 2019 was not in existence. Stop, he submits that Regulation 2 bracket small Roman 1 of the amendment regulation clearly provides that the same does not cover to those batches of students who were admitted to their MBBS course up to the year 2018-19. Stop. In other words, the same is only applicable for those who took admission from the academic year 2019-20 onwards. Stop. He therefore submits that the impugned communication dated 20/2/2024 cannot be sustained and the same should be set aside. Stop. He also submits that the other two persons whose name appear in the impugned letter also approach this court by filing WPC number 2447 of 2024 and WPC number 7304 of 2023.
Lordship, that would be 2780 of 2024. Lordship, the second writ petition which you have mentioned,
You have given,
it would be 2780.
you have given me the wrong order then.
No, Lordship, in that two writ petition are tagged with linked, Lordship. Second page.
Okay.
Page number 3, Lordship, 2780 of 2024.
What did I say? Last line. The second number you cancel and WPC number 2780 of 2024. Stop. Both the writ petitions have been allowed by orders dated 14/5/2024 and 10/4/2025 respectively. Stop. He therefore submits that a similar order may be passed in the instant case. Next para, Mr. Vaidya, Learned Standing Counsel, NMC, submits that it has been clarified. What is this UGMBB?
My lord, the UG,
MEB?
my lord, the National Medical Commission operates by forming different boards, my lord. This is the Undergraduate Medical Education Board, my lord. Under the NMC, my lord.
As per the instructions received from the President of Undergraduate Medical Education Board,
My lord.
the petitioner who belongs to the batch of 2014. Before batch, you had academic batch, who belongs to the academic batch of 2014. Admittedly, is a batch prior to the year 2018-19 session. And therefore, the cap of 10 years to complete the MBBS course would not be applicable in this case. Stop. Mr. D. Upamanya, Learned Standing Counsel, Health Department, also endorses to the submission of Mr. Vaidya. Stop. Therefore, upon considering the submissions made by the learned counsels for the parties and upon perusal of the materials available on record, it is seen that the petitioner cannot be covered by the cap of 10 years for completion of the MBBS course as provided by 11 point provided by regulation 11.2.6 of the amendment regulation 2019. As he admittedly belongs to the this session prior to 2019-2020. So accordingly, the impugn communication dated 20/2/2024, insofar as the petition is concerned, is found to be unsustainable and the same is set aside. With the above observation, direction to petition stand referred. Correct.
Obliged, your lordship.
Deeply obliged, my lord.
We'll have to just call, we'll see.
Take it on some other hearing, your lordship. Actually, Mr. Fuya is also leading a eviction series matter in another court, lordships.
All right. Due to paucity of time, the matter could not be taken up today. This is the matter again on so and so. Give a date.
Hearing date. Problem.
For hearing. Same thing with item 27 also. And I think 28 and 29.
2029 may come on 19th of May, lordship.
What is the urgency?
There are two patch of.
There is an office note. What is this? And item 28. Is it possible to have a 19th? What is the situation? Okay. Twenty-six five.
Yes. Obliged, lordship.
27, give a date. 11/6.
In this matter, we have filed our affidavit, but it is not tagged with the record. We have filed our affidavit.
27.
On 6/3/2020.
Item 27.
Yes.
What date you have given? 11/6. Please write one more line. The registry shall, no, one like that, rather this. Mr. U. Sharma, Learned Standing Counsel, High Elementary. Secondary Education Department submits that the department has already filed the counter affidavit, but the same is not tagged with the record. Staff registry shall verify and connect the same to the record. Okay.
We have filed our affidavit on 6/3/2026.
You can note that. 6/3.
2026.
26. Okay. Okay.